Recording in progress.
Hello and welcome back to Trial TV Live's continuing coverage of Iowa versus Todd Mullis. This is Todd's post-conviction relief hearing, day 5, afternoon session. So court is in session, so we're just going to get right to it.
Good afternoon. We'll go back on the record. Mr. Firehelm, are you able to hear me? And you are muted currently.
Yes, I can hear you, Your Honor.
Okay, you are very quiet. Is it possible for you to turn up your volume?
I have it as high as I can get it.
All right, I'll see if we can turn up ours, maybe. All right, would you try it again for me, please?
Yes, Your Honor.
All right, that's much better. Perfect. Okay, counsel, I think we're picking back up with Mr. Firehelm's testimony. Is that correct?
Yes.
All right, Mr. Firehelm, I will just swear you in again quickly since it's a new day. If you'd raise your hand. Do you swear the testimony you're about to give will be true and correct?
Yes, Your Honor.
All right, and I know that the camera angle is not the greatest, but hopefully you can see counsel well enough. Counsel, if you need to move or adjust yourself in the courtroom, please feel free to do so.
Thank you, Your Honor. Thanks for coming back today, Mr. Firehelm. We appreciate it. I wanted to pick back up discussing the discovery that you were tendered before Mr. Mullis's trial. Do you recall if that discovery included audio and video files?
I believe it did. I'm not 100% sure.
Mr. Firehelm, for some reason we lost your video. I'm not sure. There you're back. Okay.
Do you recall specifically audio and video of an interview with your client, Todd Mullis, November 16th, 2018?
If that was the interview by DCI, I believe he was at the law enforcement center. Yes, I do.
Do you recall reviewing one of Tristan Mullis, done by DCI, November 16th, 2018?
I think so, yes.
And are you familiar with investigative techniques such as the Reed technique?
Yes, I am.
And is it your understanding that the Reed technique is designed to obtain a confession from a suspect?
I believe so, yes. That's my reading of it.
Did you consider or investigate whether the DCI agents were utilizing such techniques on Todd Mullis and Tristan Mullis?
I didn't match up their technique with the Reed technique, although I've seen DCI use it pretty consistently.
And Your Honor, I'm going to object on this point solely for the fact that evidence already within the record has testimony that's been uncontroverted essentially at this point. As Special Agent Turbot testified, he did not use the read technique, if I remember correctly.
Overruled.
Mr. Firehelm, I think my question really is that you had some education or knowledge about interrogation techniques at the time you represented Mr. Mullis?
That's correct.
And did you take any actions or conduct any investigation to have those interviews reviewed by somebody more knowledgeable than you?
No.
Could you have consulted an expert regarding coercive interviewing techniques?
Yes, yeah, they're expert for everything.
Did you consider investigating or locating any witnesses that could testify to Todd's good character?
I didn't. Bob had a lot more contact with local people and family than I did.
Great, thank you. I know yesterday we talked a little bit about the 911 call that the state played during trial. Do you remember that discussion?
Yes.
Do you recall if you listened to it before trial?
Yes, I'm certain I did.
And then do you recall ever playing it for Mr. Mullis?
I do not recall doing that, no.
During Mr. Mullis's cross-examination, did you consider objecting to the mischaracterization by the prosecutor that Todd was alone at the time of those purported statements?
No, I don't think so.
Did you investigate the timing of the purported statements in order to contradict that state's argument?
Are you referring to the cross-examination questions or that claim by the prosecutor that he was whispering something to her? Is that what you're referring to?
Yes.
That wasn't an issue. There was no warning about that at all until it happened.
And so you weren't able to look into the timing of those statements?
No.
If you had had notice of those statements, could you have done some investigation to learn whether another deputy or another person was on scene at that time?
Well, I think it was pretty clear there was another deputy on scene. There was back and forth between Todd and a deputy before that allegedly happened.
Okay, and you didn't point that out during trial?
Again, it came up right there at the end in almost the last question she asked him or presented it to him. So no, I didn't.
Thank you. I want to move on now. Do you remember the name of a witness, Tom Krogman?
Yes, I think so, yeah.
Do you recall there being a DCI interview that included audio?
I don't. I'm not saying there wasn't, I just don't recall it right now.
Do you recall in your review of the discovery, DCI agents telling witnesses that the medical examiner's opinion was gospel?
I don't remember that being said.
Did you consider calling Mr. Krugman as a witness at trial regarding his observations during the emergency medical services on the side of the road or his observations at the hospital?
I don't think so, no.
Do you recall an email between you and Mr. Sabers about whether you should call Mr. Krugman?
Not specifically, no.
I didn't make it. Hey, Josh.
Just a moment, Your Honor. I think I'd like to refresh the witness's recollection, but between the Zoom and the sharing, I need just a moment here.
Okay, just let us know when you're ready, please.
Your Honor, at this time, we'd like to share our screen to show an email to Mr. Firehome, but we're not seeking to admit it. It's just to refresh his recollection.
Okay, is this something that has been marked as an exhibit that we can refer to for the record, or?
It is not, Your Honor.
All right, counsel, are you aware of what's being displayed to the witness?
Yes, Your Honor.
All right, go ahead.
For the record, Your Honor, I think our next number is 977. Mr. Firehome, can you see that?
Yes.
If you would just review it and let us know when we can take it down.
Okay.
So did Mr. Sabers and you discuss calling Mr. Krugman as a witness for Todd?
That was September 13th, I think. There was such a flurry of emails going back and forth then. I don't specifically recall that one, but I do now remember Bob bringing that up, and I don't know if we talked on the phone or just traded the emails about it.
And that would have been right before the trial started. Is that your recollection?
Yeah, just a few days before.
Okay. I want to move on a little bit here and ask, are you familiar with the field of biomechanical engineering?
No.
Do you
I know what it is, but
I'm sorry.
I'm sorry I interrupted you. I know what it is, but I'm certainly not an expert or that knowledgeable in it.
Did you consider consulting an expert in biomechanical engineering to investigate whether Amy could have sustained her injuries in a fall?
No.
Did you consider or investigate the principles of force that could be generated from a fall versus a strike or a swing of the rake?
I did not.
I want to show you Exhibit 233, which we looked at yesterday. It's a letter from Mr. Mullis to you. I understand, I think it's undated.
I can see it, yes.
Okay, thank you. And if we can scroll, I think it starts on page 3 and 4. They're very small for me. Did you understand Mr. Mullis to be asking questions here about investigating a theory that Amy died from an accidental fall?
Certainly that's what he's referencing there in the photos or the drawings that he made, but I don't know when. Without a date.
Would you agree that this would be a letter that Mr. Mullis sent you before trial?
Oh yeah, yes.
And do you recall Mr. Mullis asking you to investigate how the far right tines did not come out of Amy's body?
I don't remember that specific question, no.
All right. If we could go to the first page, bottom paragraph. Could you review that for me?
Okay.
Would you agree that Mr. Mullis is asking you to verify the possibility of it being an accident?
That's what it says, yes.
And then on the second line, never truly, was totally out of the far right wound?
That's what it says.
So would it be fair to say that you weren't considering, the principles of physics or Newton's law of motion when you reviewed the autopsy report?
Excuse me, can you say that again?
Sure. Is it fair to say, based on your prior testimony, that you weren't considering the laws of physics or like Newton's law of motion when you reviewed Dr. Cruz's autopsy report?
No, I wasn't considering that type of technical analysis.
And because we're lawyers, that's why we would hire an expert?
Yes.
If you had evidence before Mr. Mullis's trial that a swing of the corn rake could not have generated enough force, would you have presented that to the jury?
I guess you start out, if we had that, if evidence or witnesses are helpful to a case, of course you present it.
And if you had talked to an expert and that expert explained to you that the laws of physics made it impossible for the corn rake to have been swung into Ms. Mullis, would you have presented that to the jury?
Based on that hypothetical, yes.
If you had evidence that it was impossible for the corn rake to have been pushed or kicked into Ms. Mullis, would you have also presented that?
Same answer.
Did you present any evidence that Mrs. Mullis' death was the result of an accidental fall?
No.
And when Todd took the stand to testify, did you ask him any questions that would support that Ms. Mullis' death was the result of an accidental fall?
There may have been some questions about what he told law enforcement and medical people right after this happened, but I don't recall. I don't think there would be any other place in his testimony or I would have questioned about that.
Did you present any testimony or evidence about the prescription medications that Amy Mullis was taking at the time of her death?
I don't think so.
Did you consider or present any testimony or evidence that Amy Mullis was anemic at the time she died?
I don't think so. Todd may have testified about her being weak and dizzy when she was out in the barn helping get things cleaned up, but I don't remember if there was any specific evidence about any medical reports or evidence about her being anemic.
Do you recall in your opening statement telling the jury that Ms. Mullis was deliberately and viciously murdered?
I don't know if I use those words, but yes, that's what I was telling the jury.
Okay. I want to circle back to the text message evidence that was presented at trial. Do you remember there being text messages as a topic with quite a few witnesses?
Yes, I think so.
Do you recall there being witnesses who testified that Amy was unhappy or scared of Todd?
Yes.
Did you obtain copies of the full text messages or cell phone records for Amy and Todd Mullis?
I don't think we had 100% of the records. No, if that's what you're asking.
If we could show the witness Exhibit 307, the first 18 pages only. Mr. Fireholm, do you know if you've seen this document before?
The best answer I can give is I don't think so.
If there are text messages between Todd and Amy that contradicted what witnesses said at trial, would you have used those?
I'm not sure what you mean by contradict.
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Your Honor, I am going to object on the grounds of 5403 and relevance. This evidence is not admissible, and so it's immaterial, but it's also a report that was generated by Mr. Castle and wasn't a part of the underlying record at the time Mr. Firehelm even represented them.
I guess, Ms. Nichols-Cook, did you want to respond to that?
Well, Your Honor, it's already admitted. I am not asking this witness to admit it. It's the whole point, right? He didn't have this information because he didn't request it, and he could have used it. To impeach the witnesses at trial that talked about messages with Amy that the state relied on.
Right. Kelly, can you read me back what the question was?
Would you characterize the state's evidence as attempting to, paint a picture of discord between Todd and Amy or tension?
Yeah. The objection's overruled.
Mr. Firehelm, do you need the question again?
Please.
Did you understand the state's evidence at trial, or would you characterize it to be attempting to show that Todd and Amy were unhappy, or that there was tension in their marriage and in their home?
Yeah, I think that's fair.
So we're going to scroll down here. What page? Page 14. And I think I can direct you to line 233. And then 234 after it.
You need to scroll a little bit. I can't see 233. Okay.
Can you tell me what the dates are for line 233 and 234?
October 14th, 2018.
And this would have been shortly before Ms. Mullis passed away?
About a month.
And would you agree that the content of these messages contradict the state's narrative?
Yeah, those two do, yes.
Okay, we can take that one down. Mr. Firehelm, did you take any steps to impeach or discredit the witnesses who testified at trial regarding Todd and Amy's relationship?
Well, I guess the record would speak for itself. I think we cross-examined them, but I don't recall specifically.
I'm sorry. Did you take any steps to determine if Amy Mullis had a Facebook account?
I don't remember.
could it have been helpful to you to present evidence from Amy that her and Todd were happy?
Yeah, I suppose it could have been interesting or relevant to the jury, inconsistent with what was going on, but
So, Mr. Firehelm, do you recall reviewing phone records from Terry Stainer?
I might have, but I don't think so.
Do you recall Terry Stainer's testimony at trial?
Not in any way I could talk about it today.
If I represented to you that the transcripts indicate that Terry Stainer was testifying about Amy being upset or scared of Todd, or that she testified about Amy saying, "Look for me in the timber," would you agree with that?
Yes, I think so.
If we can show the witness 372. Do you know if you've ever seen this before, Mr. Firehelm?
The best I could do is I don't think so.
And can you tell what it is?
It looks like phone records, and at the top it says David Stainer.
If these phone records would have impeached Terry Stainer, would you have used them at trial?
Sure.
If they would have discredited her about Amy coming to her house crying in October 15th, 2018, would you have impeached her with proof that Amy didn't?
Sure, anytime you can discredit a witness, you try. I don't know how this would do that, but yes.
Okay, we can take that one down. Mr. Firehelm, do you remember a witness by the name of Corey Volker?
I don't recall that name.
You don't recall any investigation into Mr. Volker's relationship with Amy?
I'm not connecting that name with her, no. Do you recall having
in discovery text messages between Amy and Corey Volker?
I'm not recognizing that name.
Would you be surprised to learn that Mr. Volker knew about Amy's affair with Jerry Frazier?
Again, without picturing him or linking him somehow, I'm at a loss here.
We could show the witness 268. So, Mr. Firehelm, can you look at this and tell me what it is? To the best of your, I guess, ability to identify it.
It's SMS text messages. It says Corey Volker.
And have you ever seen this before?
I don't think so.
Okay. Okay, we can take that one down. Do you remember there being witness testimony about Amy screaming and getting into a fight or being upset with Todd? Oh, looks like Mr. Firehelm is frozen.
Mr. Firehelm, are you able to hear us?
Yes, I can.
Okay. Looks like your video is frozen.
I don't recall a screaming match between Amy and Todd, no.
Do you recall any text messages about Amy screamed?
I'm not recalling it today, no.
And did you do any investigation to determine the facts surrounding the text messages the state presented at trial?
No, I don't recall at this time.
Mr. Firehelm, you might want to turn your camera off and turn it back on. It looks like you're still frozen here, but we can hear you.
Right now, I've lost that bar at the bottom where I can turn things on and off. All I have is that exhibit in front of me right now.
Oh, we've taken the exhibit down, so I am not sure what advice to give you. Oh.
You see me now?
Yep.
Okay.
We're back. We talked a little bit yesterday about Todd asking you to have the accident theory investigated. Do you recall that?
Yes.
And I wanted to clarify if it was your testimony that Todd Mullis was just shotgunning, and if you could explain what that characterization means.
Well, Todd would write these long letters. Well, not all of them long, but there was a lot of it. And there would be ideas or questions and so forth. And like I said, since I couldn't email him back, we would either when I went to see him at the jail or when we talked on the phone, we would address those things. And that's how I kind of interpret Todd told me and Bob, I'm just sitting here, I'm thinking, I'm putting these things out there. That's kind of what I meant.
Okay, that helps.
I didn't mean what he was doing was inappropriate. It's just that's kind of the methodology that went on between the three of us.
Do you recall answering Todd about whether the 2 tines ever came out of the right 2 wounds?
I don't remember that type of specificity. I don't think we did, no.
Would you say that Todd consistently asked you about evidence that Amy's death was the result of an accident?
Earlier on, yes, and maybe continuing for a while, but I don't think that was a big issue as we came down the stretch towards the trial.
Do you recall testifying in your deposition that Todd never stopped asking you to investigate whether it was an accident?
I don't recall that specific question, no.
If we can... What's the exhibit number? We will show you your deposition, Mr. Firehome, just a moment here.
I have it here if you want to give me a page.
Yes, if you could turn to page 23 and look at line 5. Yes, page 23, line 5.
Okay, I see it.
And so in your deposition, you testified, no, Todd never stopped asking about experts in an accident theory?
That was my answer, that's correct.
Okay. I want to touch on communication with Mr. Mullis briefly. I believe you said you testified that Todd would call you from the jail before trial?
Yeah, I remember there were phone calls, yes.
Did you have concerns about the confidentiality of those phone calls?
I don't remember if the jail staff assured us that they would be confidential or not. I think they did, but I'll answer your question. No, I didn't have a concern.
So do you recall telling Todd that you couldn't say a whole lot on the calls when he would call you?
I don't remember that, no.
Do you know if you scheduled legal calls at either the Buchanan or Dubuque County jails?
It would just be a wild guess. At Dubuque, we would have had to have done it in the evening, and I think I was there. I'm pretty sure it was more than once. I know the night before the trial started. I went there on a Sunday night. But I think there were more than that.
I want to pivot now to your opening statement at this trial. Did you discuss that with your co-counsel, Mr. Sabers?
I think Mr. Sabers was there the night before the trial started. And whether or not we talked about the opening statement, I don't remember.
Do you remember testifying in your deposition that you didn't give him a copy or a draft of your opening?
That would be accurate. I don't remember specifically in the deposition, but that would be true.
That night before trial began and you met with Mr. Mullis in the Dubuque County Jail, did you tell him what the substance of your opening statement was going to be?
I don't remember.
Okay, I want to pivot again. I'm sorry. I feel like I just keep jumping. You testified yesterday that you visited the Mullis farm, and I believe that you looked into the shed and kind of in the farmyard.
We went to the shed where this took place, and I don't think we went into the other buildings, but Lynn and Mike pointed out, I'm pretty sure Mike was there, what the other buildings were, and like there's the 2 hog barns, there's the machine shed, and so forth. And then I think it was just Lynn and I went in the house and sat and talked.
Do you recall taking any steps to learn what Amy was doing before her death in the hog barn?
What she was doing in the hog barn?
Right, before she went to the shed?
Just what Todd and Tristan testified to. And that's what Todd had told me in our conversations.
So, do you recall there being injuries to Amy's right hand?
I don't recall specifically, no.
Do you recall doing any investigation to determine if they could have been caused by cleaning the light fixtures in the hog barn that morning?
There was no investigation as to that, and I don't remember Todd or Tristan saying that had happened. Todd said he was concerned about her balance and being she was trying to do too much after this medical procedure.
So, Mr. Firehome, I should have shown this to you yesterday, so I apologize, but this is demonstrative 275. I don't know for sure which camera I'm trying not to cough. Do you know if you've ever seen this before? We're going to try another camera. Do you know if you ever saw this before?
I don't think so.
Did you ever consider if Amy was cleaning these and putting her hand in there that it could have created injuries on her hand?
Objection, speculation.
Sustained.
Did you ever consider if the hog barn light fixtures could have caused an injury to Amy Mullis's hand?
No.
Thank you. Thank you, Tom. Do you recall doing any investigation into farming accidents as a theory of defense?
No investigation into that, no.
Do you recall examining the corn rake that officers seized from the farm?
During the trial, yes.
But not before. Is that what you're telling me?
Yes.
So did you see the blood on the handle of the corn rake?
Not before the trial.
Did you take any investigative steps to determine how the blood would have gotten there or whose blood it was?
No.
Do you recall Todd asking you in letters to look at the rake and the physical evidence?
I think he did, yes.
Did you ever look at Amy Mullis's clothing from November 10th, specifically the coat, the sweatshirt, and the long sleeve shirt that she was wearing when she was injured?
No.
Did you take any investigation into the holes in the clothing in relation to Amy's injuries on her body?
Well, when you say investigation, I mean there were photographs in the reports that were made part of the discovery, but any specific investigation or having some independent person look at them and so forth, no.
Did you take any steps to reconcile Dr. Cruz's opinion that the rake would have been swung 2 to 3 times, but there were only 4 holes in the coat?
No, I don't think so.
And Mr. Firehelm, are you looking at your deposition? I see you're looking down.
I have it right here in front of me, yes.
Okay.
Any objections to that?
Do you recall looking into the security camera system at the Mullis farm?
There's either Mike or Lynn showed it, the one camera over in the machine shed, I think, that was not functioning.
Do you recall testimony from state witnesses that the security cameras were not working November 10th, 2018?
I don't know if they testified that all security cameras were, but the only one I remember there being concern or testimony about was that one, because I think it would have been directed towards the shed where this happened.
Do you recall Deputy Himsath testifying that the cameras had been turned off?
I think he did, yes.
If you had evidence that Todd was not on the farm when that happened, would you have presented it to impeach Deputy Himsath?
I'm not recalling Himsath's exact testimony about whether or not he thought Todd turned them off or when they got turned off. So I don't know how I would have used it.
Do you recall an inference that in committing murder, Todd would have turned the cameras off that the state was trying to make?
Well, yeah, I think they were trying to create whatever inference they could.
And if you could have rebutted that inference, would you have?
Sure.
Did you do any investigation to determine whether Amy Mullis or her boyfriend Jerry Frazier could have turned off their surveillance cameras to hide their affair?
No.
And you didn't consult any expert about the surveillance footage?
No.
And do you remember doing any investigation as to whether the camera lost signal versus things were deleted?
No.
Okay. I think yesterday we talked a little bit about hearsay objections and your motion in limine. Do you remember that?
Yes.
Did you know that by failing to make an objection during trial that you were waiving that issue for appeal?
Yes.
Did you have any discussions with Todd about waiving that appellate issue?
No, I don't think we did.
If the transcripts reflect that you didn't make any hearsay objections during the testimony of Terry Stainer, would you agree with that?
I think I would, yes.
Would the same be true then for Patricia Christofferson
I think so.
and Carrie Callanan?
Yes.
Do you remember discussions with Mr. Sabers about seeking a change of venue for the trial?
Yes.
Let me start over. Was venue changed from Delaware County?
Yes.
And where did it go?
Dubuque County.
Did you consider asking for an additional change of venue from Dubuque County?
I don't know if we considered filing another request. I think Bob actually maybe was the one that made the comment that we had gone from the frying pan into the fire as far as publicity and so forth.
Did you know if both Delaware County and Dubuque County share a media market?
Yeah, well, I know that from growing up, the Telegraph Herald comes out of Dubuque, the daily paper, and the Waterloo TV station cover, I think, both counties.
Do you recall expressing frustration to your co-counsel that a jury in Dubuque was not going to be any more neutral than one in Delaware?
I don't know if I said it or Bob said it or we both did, but that's certainly.
Did you have any considerations about whether a jury in Dubuque would have a fair cross-section representation of jurors?
I don't know if that was a comment maybe made by the trial judge or by somebody in the room, so to speak, that it was just a more populated county than Delaware.
Do you remember considering or researching whether farmers are excused from jury duty in September due to harvest?
I didn't research it, but I've certainly had trials where farm chores and field work came up as an issue about whether or not a person stayed on the jury or not.
Do you remember any investigation or research into what kinds of jurors you thought could be fair and impartial?
I just relied on my experience.
Do you recall investigating whether Todd was planting crops or harvesting at the time of any of the Google searches that the state attributed to him?
Well, I know certainly Todd told us that, which I think was confirmed by Mike or Lynn or both.
Did you do any investigation or seek any documents that would have confirmed Todd was operating the planter in April and May of 2018 during these questionable Google searches?
No, I don't think so.
Are you familiar with the Farm Acre book and farm insurance?
Familiar with what?
A Farm Acre book and the concept of farm insurance? Crop insurance, I'm sorry.
No, I'm not.
If you could have produced evidence that Todd did not have access to the iPad or the internet on the dates of those searches, would you have presented that at trial?
Yeah, sure.
Do you recall telling the court that you had a family issue come up during this trial?
Yes.
And would that have been distracting to you?
It was concerning, yes.
I want to talk a little bit about Jerry Frazier and your references to him or your plan with regards to evidence about Jerry Frazier. Do you remember who he is?
Yes.
Do you recall in your deposition explaining that you were going to point to him as a possible perpetrator that was part of your plan?
Yeah, I think so.
Did you have any evidence that supported that Jerry Frazier had come onto the Mullis farm November 10th and attacked Amy?
I don't recall that.
Do you recall deposing Jerry Frazier?
Yes.
Do you recall whether he had an alibi for the time that she was injured?
I believe he did.
Did you have any other evidence that you were going to present at trial that supported Jerry Frazier being the perpetrator?
Nothing other than his relationship with Amy.
Did you have any other evidence to present that someone else was on the farm that day?
No.
Do you recall your closing argument?
Not really. Not any specifics.
Do you recall arguing that it was a murder mystery?
I might have said that. I don't know.
Would you defer to the transcript?
Yes.
Have you ever challenged chain of custody or contamination of evidence in a criminal case?
Yes.
In your representation of Mr. Mullis, did you investigate how the corn rake was handled by law enforcement?
I don't recall doing that, no.
Do you recall considering whether additional forensic testing of the rake could be helpful to you?
I don't recall considering that, no.
Can I have just a moment, Your Honor? I think I might be done.
You can.
I'm going to step away and lock my front door so we don't get interrupted.
Okay, thank you. Mr. Firehome, my last question. Do you remember there ever being a time that Todd Mullis agreed with you that Amy's death was a homicide?
I don't think he ever said those words, no.
Nothing further from the applicant, Your Honor.
Cross-examination, Mr. Duden?
Yes, Your Honor, but I wonder if now's maybe a good time to take an opportunity for a bathroom break and to reset. If possible, we could take like a 10-15 minute recess if that's okay.
We certainly can. Let's go ahead and take about 15 minutes. We'll plan on picking up at 2:25. Mr. Firehelm, I will just leave the Zoom on so you can stay logged in and everything should hopefully still be operational when we come back. Court's in recess until then.
All right, so they're taking a break, 15-minute break. I'm assuming that wind is coming from front that's going through. It's Iowa, right? Who's out there that is there a front going through? Baca, didn't you say it was really windy? There was your roof was going to fall off, blow away or something this morning? Tammy and KS, is it windy out there? Do you guys have a front going through? All right. This recap is going to be off the chain. All right, so coming back from lunch, Gerald Furhelm, who was Todd's attorney from the trial. So they start off with, were you there for Todd's interview and Tristan's interview? He said, yep. Did you know that, the read technique is designed to get a confession from a suspect? He said he knew about that. Bob, okay, so he kept talking about Bob Saper. So Bob Saper was his co-counsel. I don't remember Bob Saper, to be quite honest. I have Aaron Hamrock. So I don't remember who Bob Saper was. Anyway, so he mentions Bob all the time. So Bob had more contact with local people and family than he did. Did you talk to him about Mr. Krogman being a witness? Are you familiar with biomechanics engineering? He says, I know what it is, but I'm not an expert. And every answer he gave, he was very hesitant, very, thinking about it. So that's good. He wasn't just like, whipping these off. Whether he was really, truly thinking about them or he didn't remember, whatever, that's up for debate. Did you consider consulting an expert in biomechanical engineering? No. It's probably about the 10th time that he said he didn't consult an expert. He should have. He should have had expert after expert. When Deputy Hemiseth, Travis Hemiseth, in the original trial was talking about the whole UTC, and we were freaking out, and we're like, he was getting it wrong. I'm like, where's the expert to counterbalance? Because there's always, right? There's always an expert. Where's the expert to counterbalance? The ME. There's always. It's battle of the experts, right? We know that. So he didn't call a single expert. That alone to me means Todd should get a retrial. But that's where I land with this. Todd wrote a letter. The far right tine didn't come out of Amy's body. Never truly was out of the far right wound. Interesting. He presented no evidence that Amy's passing was a result of an accidental fall. No evidence. And then there's text messages between Todd and Amy. Okay, so I thought this was interesting. I pulled these up. Let's check these out. Because you can actually read some of these. All right, let me see. All right, so this was a text message. This was a text message. If you guys can see, 233. Sent to Todd, says love you too, but then from Todd, okay, love you. So I guess, okay, so Todd's saying, okay, so you got to read it from the bottom up. So reading from the bottom up, not too bad then, good corn, very brittle, good night, got field around buildings done. Night, we'll let you know what tomorrow plans are sometime tomorrow, not even sure yet. And then Todd says, okay, love you. And then Amy says, love you too. So that completely contradicts, I'll leave that up for a little while. Completely contradicts that they were at odds with each other. Why would you be saying that? I mean, of course, people lie. I get that. And that's October 14th. So would you have used the text messages between Todd and Amy to impeach the trial witness? He said, sure. Was the state attempting to show Todd and Amy were unhappy and there was tension in their marriage and home? He's like, yeah, I think that's fair. Clearly there was not. There they are saying, love you too. The state tried to paint discord between Todd and Amy. So the content of messages contradicts the state's narrative. He says those two do, yes. So, okay, love you too. Did you check to see if Amy had a Facebook account? He says, I don't remember. Then they talk about Terry Stainer's testimony. Amy was upset and scared of Todd. Look for me in the timber. If I go missing, look for me in the timber. We remember her. We definitely remember her testimony. If the phone records, if phone records would impeach Terry at trial, would you have used them? He said, sure. If it would have discredited her saying Amy came to her house crying, would you have used it? He says, sure. Anytime you can do that, you try, but I don't see how this would do that. So I guess her phone records, she said, oh, Amy came over and she was crying, but maybe her phone records show that she was, 100 miles away or something. I don't know. Because they didn't show that. And then Corey Volker. All right, then there's Corey Volker. Who the heck is Corey Volker? Corey knew about Amy and Jerry's affair. All right, and then I was able to grab this. It's really hard to read, but I was actually able to grab this screenshot, but it's really hard to read. But let's see if we can, I'm going to pull it up. All right, this is really hard to read. But it's something in there. I like to win. Something then. I got leverage. You already do win. Why would you need it changed? I can't quite read all that. I don't know if there's swear words. Who the F send? So this is Corey Volker. I have no idea who this person is, but clearly he's talking either to Amy or to Jerry. I'm not quite sure who he's talking to there. Yeah, I don't. So that's the first time I've heard Corey Volker's name. So I'll just leave that up for a little while. I don't know who Corey Volker is, but he knew about Amy and Jerry's affair apparently. Mr. Fernhelm didn't talk about the 2 tines coming out. There's a deposition stating Todd never stopped asking about the experts. So Todd was always saying, do you have an expert? Do you have an expert? Do you have an expert? Todd called from jail. He doesn't remember if they would be confidential calls, but he didn't have a concern. He said he visited the farm. He went to the shed. Then he went back into the house to talk. I think it was to his parents. I forget. Anyway, he went back into the house to talk. There was no investigation into Amy's hand and cleaning the lights. Todd was more concerned about Amy's balance. So then that's when he showed that glass. And I think that was just a representation. I don't think that was the actual thing that screwed into. I don't think so. Could be wrong. But there was no investigation. Okay, yeah. Did you look at Amy's clothing at all? Nope. You didn't even look at Amy's clothing? Oh, my God, dude. He didn't have an independent party look at Amy's clothes. Did you do any investigation into whether Amy or Jerry had turned off the cameras to hide their affair? He said no. I mean, you have to at least look at all of this. He didn't look at a single thing. He just literally took it on face value. Todd saying it was an accident. I think it's a murder. I'm not even going to bother looking at anything else. Did you consult any experts on the camera? No. You didn't investigate if the cameras lost signal. The whole motion about hearsay. So he did this motion in limine about the hearsay about these friends that worked at the hospital, and I think three or four of them were saying, Todd was gonna, do bad things to Amy and all this stuff. So, did you know that by failure to make an objection during trial, you were waiving that for appeal, and you didn't even talk to Todd about that? He did talk to Bob Saper about a change of venue. They did move it from Delaware to Dubuque counties. Todd could have been planting crops when the Google searches were taking place, so they talked about that. He didn't do anything. He didn't even check into that. Then he had a family issue that came up. Would that have been a distraction? He said it was concerning, yes. Then they talk about Jerry Frazier was going to point to him as a possible perp. Was that part of the plan? Yeah, that was part of the plan. Did you have any evidence that Jerry came to the farm on November 10th? He says he didn't recall. Did Jerry have an alibi? He said, I believe he did. His alibi was that he was with his son the entire time, but there was some cell phone tower pingage that happened that he was like 45 minutes away or something like that. That's why the police checked him off. Was there ever a time Todd agreed with you that Amy's passing was a homicide? I don't think he ever said those words. No. So Todd never believed this was a homicide. He always felt that this was an accident. All right, what are you guys saying? Therapist, yes, it's the main Miss Cook, Erica Cook, Nichols Cook. She's a lot better than Steenson was. Therapist, I missed this cross because of supervised phone calls. Was it crossed on the previous lawyer? Yes. How'd it go? Well, I just gave the recap, so I think it would. It just shows that he didn't do any third-party investigation. He didn't pursue anything other than this was a murder, and Todd didn't do it. That was his only path. That's the only thing he did. It was a deletion. Yeah, Brat Cook is the one some call Giggles. Brat says, I think he assumed from the beginning it was red rum and that it would be a waste of time and money to try and prove it otherwise. Never really considered the options. Never ever did. That is true. She did a little bit here and there, but not nearly as much as she did. Yeah, she was like, 5% today versus 95% the other day. All right, therapist, I covered it. Yep, no problem. You are quite welcome for that. Father, went to scene, didn't go into hog barn, but went in house to sit down and chat. Yep, pretty much. Irish Amy, Brat, true, but he could at least look into an alibi or other suspects, right? Isn't that what you do as a defense? You're supposed to defend your client no matter what. You're supposed to dig and be like, yeah, anything. And there was a lot to hold on to. It wasn't like a little bit, like straws. It was like there was a lot. There was a lot that he could have done. Look at the way we're feeling right now. Look at the way we're feeling. And if this was all presented at the regular trial, right? Reasonable doubt. Reasonable doubt. Hey, yeah, Irish Amy, shoulda, coulda, woulda. That is true. Pammy, chug, chug, chug. Are you playing a drinking game over there, Pammy? Nanar, definitely follow. Years ago, I had some couples I know come to me asking for counseling. I was an RN with no education in counseling, but they wanted me anyway, so I did. I was glad I could help. Very nice. Widespread panic. I still think Todd is probably guilty, but he deserves a new trial. I think he does. I think he deserves a new trial because I'm just looking at 75% of us yesterday thought Todd needs a new trial. 75% of us. That's pretty significant. That's pretty significant. Irish Amy, yep, that's where I am right now too. Scott R. Footy, thank you for being with us today. Imagine Sarah Boone's lawyer asking these type of questions. Or answering, I'm sorry. Sarah Boone lawyer, yeah, answering these type of questions. All right, Father, quitting time. Got to go see your sister. All right, have fun. Tackle, hug your sister. If not, have a wonderful evening, everyone. You too. Udhef, I doubt he'll get a new one. Yeah, I'm not sure how high that bar is. 75% of us think he should get a new one, so we'll see. It's not up to us. It's up to the judge. Tammy and KS, I thought differently yesterday, but after hearing this today, I think he should at least get a new trial. Yep. She's getting a huge hug. Nice. Oh, I got you, Pammy. Drunky the Bear. I do think Todd should get a new trial, but so should hundreds of thousands of other people that are in similar situations across the U.S. That's true. I was chugging my water. No, not yet. It's 5 o'clock somewhere, Pammy, as the saying goes. Yeah, I need to go get some more water myself. I had some leftover pad thai, and I'm a little parched. Might have been a little salty. All right. Yeah, those hundreds of thousands of other people across the U.S., you know, we're hearing about Todd. Hey, at least he got to this point. At least he's got a shot. He's at the, you know, Capri Law for a baseball reference. You know, Todd at least is he's at the batter's box, and he's taking his swings right now. At least he got into the game. Oh, there you go, Irish Amy. It's nearly 8:30 here. Go for it, Pammy. Oh, Capri Law, you had pad thai yesterday. Leftovers are always even better. Yes. Yeah, I made mine over the weekend, and I think this is my third and last. I have 1, 2, 3. Yeah, I think this is my third and last round of it. Right? Thought you would appreciate that. Fala, hugs to you all. Hugs to you all. Therapist, you know, pad thai. Well, it's from Thailand. Pad is a noodle. It's a flat noodle, and it's just a stir fry with
rape, for instance, as well as sex abuse and things like that as well. Yes.
Correct.
So you have a wide array of experience for high-level felonies and trying those cases. Is that fair?
Yes.
So turning your attention to this case specifically, it's fair to say, I think at this point, you would agree that you represented Todd Mullis in this case, right?
Correct.
When did you begin representing Mr. Mullis?
Probably in March 2019, I think.
If I told you that I believe you appeared in the case around March 8th of 2019, is that right?
That sounds right.
And so you appeared shortly after the criminal complaint alleging that he had committed murder in the first degree was filed, right?
Correct.
As you mentioned on direct examination yesterday, I believe you said that you were referred to this case in order to assist Mr. Sabers. Is that fair?
Yes.
Why did Mr. Sabers need assistance in your what was your understanding?
That he did not have jury trial experience at this level of offense.
And so it's fair to say that your experience would be an aid to both Mr. Mullis and Mr. Sabers in trying the case. Is that right?
Yes.
But you did not outright assume the case. You first met with Mr. Mullis' family. Is that fair?
Yes.
That included his sister and brother, I believe, right?
Yes.
And at that time, you talked about the case, right?
Yes.
You also viewed and inspected the property where the murder occurred, right?
Correct.
Is it safe to say that after you drove from I believe your office is based in Des Moines, to Delaware County, that you spent a sufficient or extended period of time discussing the case before taking on any representative role?
Yes.
Did you also speak with Mr. Sabers before assuming the role of counsel in this case?
Yes.
And of course, did you also speak at length with Mr. Mullis?
Yes.
So ultimately, you appeared in the case, but by that point, you'd spoken to multiple people about the facts and circumstances surrounding Amy Mullis's death and Mr. Mullis's charges, right?
Yes.
At all times during your representation, taking it from a big approach or kind of a macro approach before we go to a micro level, you maintained that Mr. Mullis was innocent and did not murder his wife, didn't you?
That's correct.
So at no point in time did you encourage Mr. Mullis to plead guilty, is that fair?
Yes, that's very fair.
At no point did you encourage him to plead to a lesser offense level or level of murder or manslaughter, for instance?
No, sir.
So at all periods of time, I believe, is it safe to say that you believed Mr. Mullis was innocent?
That's correct.
And that's what you held out to the jury over the course of this trial in this case, correct?
That is correct.
So in your investigative steps, as we kind of work our way up towards the trial, again, you interviewed Mr. Mullis's family, yes?
Yes.
And you regularly kept in contact, in fact, with Mr. Mullis's siblings who were assisting in providing information and conveying information between you, Mr. Sabers, and Mr. Mullis, who was very active in his case's defense, right?
That would be correct.
You reviewed letters?
Yes.
Took phone calls, is that right?
Yes.
Not just from Mr. Mullis, but also from his siblings or family.
Yes.
And in this period of time of about 6 months, it was not just at the beginning that you took these steps, but you followed that all the way through to trial as well, correct?
Yes.
Now, directing your attention to what has previously been marked and admitted as State's Exhibit F in this case, I believe Mr. Bakke is going to put it on the screen for you, if that helps as well.
I have it in front of me.
Perfect. Well, we'll jump right in then. Do you see the email correspondence marked as Exhibit F on your screen as well?
Yes.
Now, would you agree that this is an April 6th, 2019 email from you to your co-counsel in this case, Mr. Sabers?
Correct.
In directing your attention specifically to what is the first paragraph, let me know if I read this correctly. After again reviewing the medical examiner's report and the photos we do have, I'm almost certain that her death was not a result of accidentally falling on the fork. The number of puncture wounds, the fact that she had several layers of clothing on, the abrasions on her chin/jaw, abrasions on her hands that I will bet will be described as defensive wounds, all lead me to conclude it was a homicide. Did I read that correctly?
You did.
So, less than a month after you appeared in this case and the trial information was filed, this email would suggest that you believe that this was a murder, in fact. Is that fair?
Yes.
And you conveyed that to your co-counsel, right?
I did.
But this wasn't the first, this wasn't the last time that you conveyed to Mr. Mullis or even anyone interested in the case from Mr. Mullis' side, including Mr. Sabers, that you believe this was a homicide, correct?
That is correct.
Is it safe to say that you conveyed that you believe this was a murder with some regularity?
Yes.
To your knowledge, and based upon the notes, do you believe that Mr. Mullis was not supportive of proceeding with that avenue of defense at trial? Put another way, did you have any indication Mr. Mullis was not comfortable with you conceding this was a murder, but that it wasn't him?
I believe he conceded that.
That you were empowered or permitted to go to trial and argue that this was a murder case?
Objection misstates the prior testimony today.
Overruled. The witness can answer.
Could you ask that again, please?
Is it possible to read it back? I apologize.
That you were empowered or permitted to go to trial and argue that this was a murder case.
Could you hear that, Mr. Firearm?
No.
Oh, so I believe the question was, so you were, in your mind, empowered or permitted to concede at trial that this was in fact a murder, right?
Correct.
To your recollection, do you have any knowledge or recollection of Mr. Mullis telling you that you needed to correct your opening statement during questioning or the examination of witnesses?
No.
To your knowledge or recollection, do you believe that Mr. Mullis ever told you not to again say that they believe this was a murder in its closing?
No.
And do you recall that Mr. Mullis himself agreed that this was a murder on cross-examination at trial?
I believe he did.
So is it safe to say that it was undisputed that this was a murder and not an accident during the trial proceeding?
I'm going to object and ask, the question is vague. Undisputed by who, maybe, would help?
Mr. Duden, did you wish to clarify your question?
Sure. So is it your understanding that you, your co-counsel, and Mr. Mullis agreed at the time of trial and throughout that this was a murder case?
I'm going to continue to renew my objection. I don't think this witness can testify as to what Mr. Mullis agreed or what Mr. Sabers thought.
Overruled.
I don't recall either of them disputing or arguing with me about that approach.
And to be fair, as you said earlier, Mr. Sabers, in your opinion, lacked the experience in order to be able to try this case, so you became lead counsel, right?
Correct.
Mr. Sabers did not examine any witnesses at trial, right?
He did not.
He didn't do an opening statement.
No.
Nor did he do a closing argument, did he?
No.
So at all points during the trial proceeding, you were representing Mr. Mullis.
Yes.
Now looking back at State's Exhibit F specifically, I'd like to direct your attention to what is paragraph 2, where you say, quote, I expect we would need to have our expert take a look at the state's examiner's work, but I'd be surprised if he disagrees. Our money may be better spent on getting a good private investigator involved, close quote. Did I read that correctly?
Yes, you did.
So even early on in your representation, you were considering hiring medical experts, weren't you?
Yes.
And you were considering hiring private investigators, right?
Correct.
And you were going to investigate this case with the help of experts if it was necessary, weren't you?
That's correct.
But is it fair to say that during the course of your investigation, in your professional opinion with 45 years worth of experience now, that you didn't believe those experts were needed?
That was my conclusion.
Looking to the course of your investigation, you did, however, look at all of the law enforcement reports in this case, didn't you?
Everything that was provided, yes.
You reviewed transcripts of witness statements, right?
Yes.
You received and reviewed audio recordings or video footage when it became available to you, yes?
Correct. Correct.
And you conducted depositions, right?
Yes.
Before those depositions came to be, though, you also looked at this case from the perspective of electronic evidence, right?
Yes.
You actually reviewed Cellbrite phone data, or Cellbrite phone dump, for lack of a better term, that was provided to you by DCI and by the Delaware County Sheriff's Office, yes?
I believe so.
That information included a review of things like the iPad in this case, right?
Yes, it did.
As well as phone records when it was necessary or relevant, yes?
Yes.
And again, you reviewed all of that information.
Yes.
Looking to your depositions here, I believe you conducted around 16 depositions of potential state witnesses before trial, right? Around that number?
That sounds about right.
You conducted depositions of lead investigator, for instance, Special Agent Turbot.
Yes.
And if you recall, when you deposed Special Agent Turbot, you did so with the view that you were also going to ask about potential other suspects in the case, right?
I think so, yes.
And is it fair to say that during that deposition you also asked about a potential affair between Amy Mullis and sheriff's deputies from the Delaware County Sheriff's Office?
I think we got into that, yes.
And so now that individual's name, I believe you know to be Rowley as a last name, as well as potentially others, right?
I think that's right, yes.
And do you have any reason to doubt that in Special Agent Turbot's notes, he referred to Rowley as Raleigh with an A instead of an O? Does that sound or ring a bell to you?
Yeah, it kind of does ring a bell, yes.
And in fact, you asked about those circumstances in that report when you deposed him, fair?
Yes.
Drawing your attention to what's previously been marked as State's Exhibit G, do you have that exhibit in front of you, Mr. Firehelm?
I do.
And to be clear, would you agree that this is a chain email or correspondence between you and your co-counsel, Mr. Sabers?
Yes.
And would you agree that both of the messages depicted here fell or came from, were sent on Thursday, April 4th, 2019?
Yes.
So starting with your message, which is the smaller paragraph section on the second half of the page, you wrote to Mr. Sabers that you expressed concerns about irregular injury patterns, marks on the hands and arms, the large abrasion on Amy Mullis's chin or jaw. Those are one of the concerns you shared, right?
Yes.
You also mentioned that you had reviewed at least her medical information and the specifics about a bruise on her arm that was from an IV site from a medical procedure she had days before she died, right?
Yes.
So you had accounted by this point for her various injuries that led to her cause of death.
Yes.
And again, this is when you also were evaluating the potential claim of defensive wounds or injuries that were not from the puncture wounds to her back from the corn rake.
Correct.
This also notes that you went to go visit Mr. Mullis in person, right?
Yes.
And if you go to the third paragraph, it also shows that you reviewed the statements taken by individuals that you were asked about on direct, including Patricia Christofferson, right?
Yes.
And an individual by the name of Jerry, who ultimately was a subject of the case, or Jerry Frazier, is what you came to understand, right?
Yes.
So at this point, is it safe to say you were looking at this case from other potential suspects, right?
Yes.
And matters that of what happened months before even this case began.
Yes.
And so you knew about people who were supportive of Amy Mullis, for instance, or her friends in their statements, right?
Yes.
And you knew that they would potentially testify in this case too. Fair?
Yes.
If you flip to the second page of State's Exhibit G as well, there's a message dated also from April 4th there from your co-counsel, Mr. Sabers, directed towards you as well, correct?
Yes.
And in that message, you also discuss the autopsy report and accompanying photos, correct?
Correct.
And you even discussed down to the depth or distance between certain wounds, correct?
Yes.
And as we noted from your prior message, you shared a lot of these concerns, but these would potentially come to fruition to say that there was potentially more than one strike or swing, I think is how it was referred to on direct, right?
Yes.
I'm sorry, can I, objection, what portion of G are you looking at? Two?
The page 2, the full
Where does it,
paragraph of text.
what line says swipe or swing?
Oh, that was a paraphrase, a characterization used from the direct examination testimony, Your Honor.
I'm going to object to a characterization of swipe because I don't think that word was used.
Okay, I guess the record will speak for itself. We'll move forward with a new question, I believe, at this point, unless there was one pending. Mr. Duden, did you think you had a question pending?
Possibly, maybe, I don't know. I can ask another question.
All right, let's do that.
When we had discussed a swipe or a swing, for instance, what we're really referring to is the puncture wounds, right?
Correct.
And those would be known as the 6 wounds caused by the corn rake to the back of Amy Mullis's body.
Yes.
Looking to the responsive message from Mr. Sabers to you on page 1, that big block of text, do you see that?
Yes.
And in this text, if you'd like to review it, you also noted, you substantially discuss Jerry, right?
Yes.
And the other individuals, including a possible sheriff's deputy who Amy Mullis would have had an affair with, right?
Yes.
So is it safe to say that even at the earliest point of this case, you were considering other people who could have murdered Amy Mullis?
Yeah, this was very early on, beginning of April.
If you look down as well, you let me know when you see the information regarding the DNA evidence.
I see it.
In the individual at the latter third or so of that block of text, it says, quote, "I doubt that investigators did anything by way of looking for DNA in there, and by now I suppose the scene is compromised," close quote. Did I read that correctly?
You did.
So at this point, you were also considering scene integrity, fair?
Oh, yes.
And you were considering the avenues of possibly a faulty investigation or a less than thorough investigation. Is that fair?
Sure.
Which is things that you brought up at trial, actually, right?
Yes.
And again, continuing on there, Mr. Sabers came on the case before you, correct?
Yes.
And at that next sentence, he says to you, quote, "In my prior musings, I concluded that eventually finding fault with the shortcomings of their investigation would eventually be the route to follow, as opposed to hiring someone else to process the scene," right?
Yes.
So when we talk about processing the scene, we're really talking about evaluating the scene for alternative theories or looking for additional evidence, right?
Correct.
And so at this point, you and your co-counsel had considered this as a choice, right?
We did.
And so things like an accident reconstructionist, for instance, or an evaluation probably wouldn't have been on your mind as viable avenues for the defense.
It was not.
Now, you were asked about a biomechanical engineer specifically, weren't you?
Yes.
Oh, and I'm sorry, I do just want to talk about it. There was one more sentence that I figured I'd go ahead and cover with State's Exhibit G. The last sentence of Mr. Sabers' reply to you reads, quote, "That mark on Amy's chin looks like she went down onto something like the auger," close quote. Did I read that correctly?
You did.
So you knew about a potential avenue of whether or not the auger was involved in causing Amy's injuries.
Yes.
And you also knew or were considering whether or not the fall to, or the mark on Amy's chin was due to a fall injury, right?
Yes.
But it's fair to say, like before, you didn't believe that a fall was a viable avenue or claim, right?
That's correct.
And that's with more than 4 decades worth of experience predominantly focused in criminal defense, right?
Yes.
So again, returning to the discussion of a biomechanical engineer, have you ever worked with a biomechanical engineer?
I don't think I ever did with someone that had that exact title, no.
And so, have you ever heard of a case in the state of Iowa, where criminal case in the state of Iowa, where a biomedical or biomechanical engineer would provide testimony?
Sure, I read all the appellate decisions and belong to IAJ where we trade information like that.
So being aware of their work and the type of work that a biomechanical or biomedical engineer would do, you knew of that, right?
Sure.
And based on your experience and judgment, you did not believe that it was a viable avenue to do a scene reconstruction, for instance, here, right?
I did not. That's correct.
But looking to State's Exhibit H now, you and your co-counsel, again, were considering potential expert testimony in this case, right?
Yes.
In fact, you considered having the medical evidence reviewed by maybe an independent medical examiner or an expert witness in your case, right?
Yes.
Looking to what is the May 2nd, 2019 email message between you and your co-counsel, Mr. Sabers, do you see the message with the title subject being R.E. Bond?
Yes.
That first paragraph says, quote, "We can and probably should have the autopsy report reviewed, regardless of our opinion that it was not an accident." Did I read that correctly?
You did.
So in this instance, you were also considering it from the perspective of whether an accident was potentially viable.
Yes.
And is it safe to say that that claim was coming from things Mr. Mullis had told you, as well as potentially his family or support system?
It was, yes.
But as your investigation progressed, the medical information didn't seem to be necessary for you to retain your own expert, correct?
That was our conclusion, yes.
Is it fair to say, based upon the number of times you discussed it, that you actually did contemplate or research reaching out to an expert?
Sure.
And that avenue was either not proceeded with or was otherwise fruitless, right?
That was the conclusion.
Early on in the case, though, as you mentioned, I believe, or at least in your prior notes, that a bond review or lowering Mr. Mullis's bond was a primary focus at the start of the case, right?
Correct.
You spent a significant amount of work on attempting to lower Mr. Mullis's bond, right?
Yes.
In fact, you even filed for an interlocutory review or an interlocutory appeal to have the Supreme Court attempt to allow you to lower his bond, right?
Yes.
And this was noted to be a significant concern for Mr. Mullis, wasn't it?
He was extremely stressed about being in jail.
In your interactions with Mr. Mullis, he regularly was stressed about either being in a jail setting or incarcerated or the case, right?
He was, yes.
In looking down to the next message on State's Exhibit H, which was from your co-counsel to you, sent on May 1st, 2019, do you see that?
Yes.
In this message, based on your review, is it fair to say that Mr. Sabers or yourself had provided Mr. Mullis with the reports of law enforcement officers or investigators in this case?
I think Bob took those to him, yes.
And in fact, you and Mr. Sabers had expressed your questions or attempted to answer his questions too, right?
Yes.
But at this point in time, starting with the third sentence of that message, let me know if I read this correctly, Mr. Firehelm. Quote, he told me that he doesn't want to read them because his anxiety goes through the ceiling when he reads things and he can't function. Did I read that correctly?
You did.
And again, in this message, is it fair to say that you are aware of Mr. Mullis's concerns or belief that this was possibly an accident, but that he wanted to rule it out at this point in time, right?
Yes.
And ultimately at the case, he didn't tell you not to proceed with conceding that this was a murder, right?
Objection. There's no foundation for that.
Overruled. The witness can answer if he's able.
I don't recall Todd ever ruling that out. Well, would you state your question again? I may have misstated.
Sure. So Mr. Mullis believed that this was an accident early on in the case, correct?
Correct.
And he held out to you that this was a possible accident at all times, fair?
Yep.
But by the time of trial came around, Mr. Mullis himself even testified that this was a murder case, wasn't it?
I believe he did.
And so, in that point in time, prior to trial, you had prepared Mr. Mullis for taking the stand, correct?
Yes.
You intended to engage in a review of the evidence to allow him to tell his side of the story, fair?
Yes.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis, in fact, conceded that this was a murder. Fair?
I'm going to object. I think the transcript would speak for itself, and the transcript is in the record. I believe that what counsel's referring to is cross-examination, and he's misleading or mischaracterizing the testimony of Mr. Mullis and the questions that were being asked of him regarding the evidence presented at trial and whether Mr. Mullis agreed that evidence was presented that it was a homicide versus an accident.
Well, certainly I'll have the opportunity to review the entire transcript and this section in particular. Mischaracterizing that testimony certainly isn't going to be helpful if that's what's happening. So the objection's overruled. Do you remember the question, Mr. Firehelm?
No, Your Honor.
All right. I'll have Kelly read it back since there was an objection, but you'll need a microphone, Kelly, if you want to use mine.
And at that point in time, on cross-examination, on the last day of trial, Mr. Mullis, in fact, conceded that this was a murder. Fair?
I believe that's correct.
Your Honor, to clear up something, may I go ahead and present? Mr. Firehelm, I'd like to show you what's previously been indicated as Volume 5 of the trial transcript and what's previously been admitted into evidence as Exhibit 351, I believe. Directing your attention to page 56, beginning at line 12, the prosecutor asked Mr. Mullis, and somebody came onto your property right under your nose and killed her being Amy, right? That's what you're told? To which Mr. Mullis responded, that's what I'm told, right?
Yes.
And then the state asked Mr. Mullis, quote, and you know that's true now because you heard all the testimony in this case, right? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
And the prosecutor next asked Mr. Mullis, you know that somebody took that corn rake and stabbed Amy in the back 2 or 3 times? To which Mr. Mullis said, yes. Did I read that correctly?
You did.
You now know this wasn't an accident. To to which Mr. Mullis said yes. Did I read that correctly?
Yes.
So we knew where we were at trial, as did Mr. Mullis, based upon his testimony. Is that a fair understanding?
I believe it is.
And again, this is from Mr. If you know, this is from Mr. Mullis' sworn testimony while under oath, correct?
I believe it is.
Now, speaking of preparation for testimony, you believed Tristan Mullis' testimony was essential to this case, didn't you?
I did.
Is it fair to say that you understood or Tristan to be an alibi for Mr. Mullis?
I did.
But shortly before trial, there was some break in Tristan Mullis' statements regarding how long Mr. Mullis was out of his sight, right?
That's correct.
Tell me a little bit about that. What was the concern?
We deposed Tristan at Al Parrish's law office. I believe Todd, I don't know if it was video or just audio, but he was listening in. And Tristan gave his testimony as to being in the barn with his mother and father, or his mother leaving, and him staying there, helping his dad, helping Todd clean things up and make repairs and such. He testified that he went into the kind of a work area at the front of the building, I believe to get a drink of water, and then went back in the building, the main part where the hogs would be, where he saw his dad again. And he gave an estimate of how long he would have not been able to see his dad. And it was quite short. I can't remember, 30 seconds or something, long enough to get a drink of water.
Now, is it fair to say your understanding was that Tristan's testimony stated that Mr. Mullis could not have murdered Amy Mullis because he wasn't out of Tristan Mullis' sight long enough to be able to commit the crime?
That's basically it, yes.
During the course of your investigation and prior to trial, however, Tristan Mullis' testimony changed, didn't it?
Yes.
In fact, at his deposition, where he was represented by his own counsel, Tristan Mullis' testimony, for the first time while he was under oath, changed to say he couldn't recall a specific amount of time, right?
I believe so.
And that's ultimately the same sort of statement that he made at trial, if you remember, right?
I think so, yes.
Where he was also under oath, fair?
Yes.
Was this shocking to you when this occurred?
Yes. In some ways.
Because I believe, as you stated earlier, Tristan's testimony was critical in this case, yes?
Yes.
But you worked hard in order to try and convey that Tristan Mullis was still with his dad for the bulk of the time in that hog barn on the day Amy Mullis was murdered, right?
Yes, that was critical.
You asked him questions specifically about possibly the number of times that he would have gotten a drink of water or been out of the sight of his dad, right?
Yes.
You asked him about family dynamics between Mr. Mullis and Amy Mullis, didn't you?
I think so, yes.
And I believe you, correct me if I'm wrong, but was the goal to convey that Mr. Mullis and Amy Mullis were in a loving marriage and that they were a happy family?
Yes.
And you made that effort to convey this central theme with each of the state's witnesses who would potentially say something different, right?
I think so, yes.
And if you recall, during some of the witness testimony, you asked about showing they worked on their marriage through marriage counseling, for instance, right?
Yes.
That they took trips together to places like potentially the water park, fair?
Yes.
And that they were working on their marriage and being supportive. True?
True.
And I believe during your cross-examination, perhaps of Ms. Stainer, you mentioned the messages that specifically related to Amy Mullis calling Todd Mullis super dad, or something to that extent, right?
Correct.
So at all times you were working to convey not only a happy family approach, but also an approach that Mr. Mullis was a loving husband and father, right?
Yes.
And at least by the end of trial, you had even worked on reviewing those messages to keep instances of potential violence or prejudicial acts like was present potentially in Ms. Stainer's messages, for instance, out of the jury's view. True?
Yes.
And that's because you not only believed your client was innocent, but you were working to convey, a solid narrative of a united family. Is that fair?
Fair, yes.
Looking to the trial when Mr. Mullis took the stand, do you recall asking him about the hunter safety course that his daughter was a part of?
I think we did, yes.
And directing your attention to what I believe is trial transcript volume 4, which has been previously admitted as exhibit 350 in this case. In directing your attention to what is page 170, in scrolling down to the second half of the page, I believe, one moment, looking at line 10 to line 14, you asked Mr. Mullis specifically if he had Googled about cheating wives or cheating spouses, didn't you?
I did.
And he denied it on the stand, didn't he?
Yes, he did.
And similarly, going down to the next two lines, Mr. Mullis denied knowing who would have looked that up, didn't he?
He did.
Looking down to the second half, beginning, I believe, at line 22 to 24, you also asked him about potential TV shows or channels that they would have watched as a family, right?
I did.
And potentially, you also asked him, going on from line 25 to the next page, about whether or not those searches could be follow-up searches on those shows, right?
That's correct.
Similarly, you evaluated or considered how they enjoyed history and of the Native Americans or Indian populations, right?
Yes.
And that there was evidence that they would watch not only shows about this, but potentially searches would align with these topics. Fair?
Fair.
Now, scrolling to what is page 174, beginning at line 14, you also asked Mr. Mullis to explain potentially some of the searches that related to starving to death, drowning, floating, those kinds of things. Right?
I did.
And you allowed, or Mr. Mullis had the opportunity to say under oath that those topics were more normal, or when considered in context, were not indicative that he committed a murder, right?
That's correct.
You also, looking to line 22 of page 174 of the transcript, You asked about chest wounds, gaping chest wounds, surviving the cold, and other survival tactics or habits, didn't you?
I did.
To which Mr. Mullis answered, as we see mostly on page 175, that she was engaging in a hunter education program, an online thing, and that she was studying for it, and him and Amy Mullis were helping her review those educational course materials, right?
Yes.
And by her, I mean your daughter specifically. In this case, I'm sorry, Mr. Mullis' daughter specifically. We're late in the day, obviously.
Correct.
So you also asked about the hunter safety course materials specifically that have been, relevant not to just to this proceeding, but what was the underlying Google searches too, right?
Yes.
In fact, when you crossed Deputy Hemiseth, I believe, then Deputy Hemiseth, on the Google searches specifically, you asked him to review things from K Jewelers and other things like Pinterest, for instance, too, didn't you?
I did.
And in your closing arguments, you mentioned specifically that these things suggested the iPad in question or the Google account itself were not just used by Mr. Mullis. Is that fair?
Yes, it is.
So you sought, is it fair to say, to categorize your work in this case that you attempted at every turn to mitigate the Google searches and the state's narrative of what they represented?
That's correct.
Taking you back again to a pretrial evaluation and how it impacted your trial tactics. You were asked on direct examination about whether or not you were looking for witnesses to testify to Mr. Mullis's good character. Do you recall that?
Yes.
But you were actively in contact with his family, weren't you?
Yes.
And individuals like Tom Krogman, for instance, who were mentioned, were also interviewed by DCI as well, weren't they?
Yes, they were.
And in those reports that you received and provided, in fact, to Mr. Mullis, you would have considered his role in the case. Is that fair?
Yes.
And that would be both as a potential person to help you investigate the case and as a potential person to testify on Mr. Mullis's behalf, right?
Yes.
But ultimately, as a matter of trial strategy, you chose not to call Mr. Krogman. Fair?
That's correct.
For that question, I think it's improper to ask if it's a matter of strategy when the witness hasn't testified that there was strategy in not calling Mr. Krogman.
Overruled. The answer will remain in the record.
So, knowing how things impacted the case as it proceeded to trial 2, you were asked several questions about the 911 call. Do you recall that?
Yes.
Now, in all cases, you actually listened to the 911 call before trial, didn't you?
I did.
And it was a part of your overall investigation and discovery into this case. Fair?
Yes.
Did you also speak with Mr. Mullis about the 911 call and what happened prior to Amy Mullis, leading up to Amy Mullis's death?
I'm sure we discussed it, yes.
And to your understanding, is it fair to say Mr. Mullis conveyed to you that he didn't see how Amy Mullis died?
He said he didn't see how she was injured.
But he did tell you that he had pulled the corn rake out of Amy Mullis's back in order to be able to transport her to the hospital.
Can we get objection to foundation? When did Mr. Mullis say that to Mr. Firehome? What's the underlying context?
Mr. Duden, would you like to lay some additional foundation?
Sure. Early in the case, did you ask Mr. Mullis what happened leading up to Amy Mullis's death?
Absolutely.
Would that be prior to you determining what course of action or case theory you wanted to proceed with to trial?
Yes.
Would that be early on, say even before the trial information likely was filed in this case?
Probably so, yes.
So it was an early, is it fair to say that it was an early topic of discussion between you and Mr. Mullis?
Yes.
Having listened to the 911 call, that call ultimately came into evidence, correct?
It did.
And prior to Mr. Mullis's cross-examination, you had no reason to believe that the state would argue that the muttered statements under his breath that were claimed to be there were present, did you?
Had no idea.
But in response to those statements being alleged by the state, in your closing argument, you attempted to undermine the value or the claim that the statements about Amy Mullis being a cheating whore or telling her to, quote, die cheating whore was on the record. Is that fair?
Yes.
Oh, I believe it was, quote, go to hell cheating whore. I apologize for that statement. In those statements, you believed that there was heavy breathing, yes?
Yes.
In that you believed he was working to revive his wife. Is that a fair assessment?
Yes.
Your arguments at each time said that the state's asserted claims were false. Is that right?
That's correct.
Now, primarily as it relates to the heavy breathing, you were shown a potential transcript of a 911 call. Do you recall that?
Yes.
And in that transcript, when you read, do you recall reading from it?
When it was shown to me yesterday, yes.
And if you remember, in that transcript, they indicate there's things like heavy breathing, right?
It did.
So in fact, your claims or your arguments presented at closing were fairly consistent. Is that right?
I believe they were.
But is it your opinion that that ultimately came down to a weight or credibility determination for the jury?
I believe so.
And ultimately, after the trial came back and the jury found Mr. Mullis guilty of murdering Amy Mullis, you moved for a new trial and judgment, or to arrest judgment. Do you remember that?
Yes.
And you alleged that it was misconduct, in fact, to claim that those statements were made on the 911 call. Fair?
I believe it did, yes.
And so you sought to preserve that claim and also to ensure that Mr. Mullis had the fairest trial he could have, in your opinion, right?
Correct.
Now, in your more than 40 years of experience as a criminal defense attorney mostly, have you had transcripts of 911 calls be completed?
Certainly.
Have you done that yourself?
Yes.
Did you believe it to be necessary in this case?
No.
And to be fair, your arguments were to what was being said under someone's breath rather than overtly in the statements heard on the call. Is that a fair assessment?
Yes. It's my understanding that, and this was told to me by the prosecutor, that this muttering under and saying those terms was called in by someone watching on court TV, and that's how it came about.
So you weren't really assigning a lot of weight to these claims, is that fair?
That's very fair.
Did you ultimately review the Court of Appeals decision in this case?
I did.
And to your knowledge, did that opinion or ruling speak to the potential substance of the 911 call?
I think there was a footnote to that, about that, yes.
And if you recall, or correct me if I'm wrong, do you believe that that went, like you believed as well, to weight rather than a matter of fact, for instance?
Yes, I agree with that.
And that ultimately is how you proceeded in this case, right? You argued it in closing rather than sought to omit it from its admissible use.
Yes, that's correct.
And you attacked its use even after the trial.
Yes.
Correct me if I'm wrong, too. At the time that then Deputy Himiseth took the stand at trial, you even asked him about UTC time, too, didn't you?
I did.
And in that line of questioning, you talked about cell phone extractions and the specific information at hand to the electronic devices like the iPad, right?
Correct.
And your course of action, is it fair to say that it was a strategic decision to proceed with attacking his credibility when you so that you could argue what he said didn't make sense?
Exactly.
And that is what you actually did in closing too, right?
Yes.
Mr. Firehelm, you've reviewed digital forensics information before, right?
I have.
You've reviewed electronic discovery before too, right?
Yes.
And that would include even evidence from a Cellbrite phone dump. Yes?
Many times.
So you knew how to look at the records and electronic information provided to you as a part of the investigative file from the state shared during discovery, right?
I believe so.
And you talked through that discovery and those investigative files with Mr. Mullis, didn't you?
Objection.
We did.
I don't think there's been any foundation that a conversation was ever held with Mr. Mullis regarding whatever piece of electronic evidence the state is trying to ask about.
Well, certainly there was testimony that counsel reviewed discovery materials with Mr. Mullis. Objection.
Did he answer? During those periods of time, do you recall Mr. Mullis ever mentioning planting being an evaluation during, as to why he wouldn't have been able to make those searches?
That he was planting crops?
Yes.
Is that what you mean? Yeah, he talked about his schedule of long hours and working into the night.
But he never proffered it as a reason for why he didn't use the iPad, right?
Right.
And you didn't view it from the claim that that would have made it so he couldn't access the internet, true?
Correct. Right.
And in fact, when you asked him about it at trial, when he was on the stand, planting was not a reason that was provided as to why he couldn't have made those searches, right?
I think that's correct.
But still, he denied that he even conducted those searches, fair?
Yes.
So at no point in time did Mr. Mullis, to the best of your recollection, did Mr. Mullis or his family ever provide that as a proffered reason why he could not have done the Google searches, fair?
I think that's fair, yes.
Looking to what's previously been admitted as Exhibit 233, which I know has been the subject of communication previously. Hold, please, I apologize. One moment while we get that pulled up for you, Mr. Firehelm. Do you see Exhibit 233 on the screen, Mr. Firehelm?
I do.
Now, going to that last paragraph, I believe you had testified on direct examination that Mr. Mullis's inquiry about a possible quote-unquote expert, you believed it to be just shotgunning. Am I right?
Yes.
And if I understood your testimony correctly, and please correct me if I'm wrong, this was because you and Mr. Mullis had evaluated different kinds of defenses and different ways to proceed at trial well before the trial ever took place, true?
That's true.
And this included what witnesses to call, including any potential need for an expert witness, possibly.
Yes, that's correct.
But looking at this page, if you don't mind scrolling to the top, thank you. On 233, do you see where it begins at number 18?
Yes.
So in this line, is it fair to say that this looks to be an incomplete list?
Yes.
And this exhibit actually doesn't have a date on this note specifically, does it?
I don't see one.
Do you even know when this note would have been sent to you?
I would have no idea.
How, other than the notation of legal up top, would you know that this was meant for you?
That would be my guess, that if he wrote legal on there, that the jail would let him mail it or something. I don't know.
Well, knowing that, Mr. Firehelm, I'd like to scroll and draw your attention to what I believe is page 2 of this exhibit. Does this page have a date either?
I don't see one.
So like before, you don't know when you would have received it, if at all. Is that fair?
That's correct.
And you don't know when it would have been sent or what it would have been about. Is that fair too?
That's fair.
Now, if you want to go ahead and review a little bit of this text, Mr. Firehelm, specifically the first 3 sentences, I'd like to ask you about the context of what this letter shows for you.
Okay.
Now, when you're going through this message, do you note that there's various individuals and different witnesses that the state called at trial?
Yes.
In conversations about the inclusion of, say, porn or the testimony of someone being critical, this case being Tristan, was important for not only trial purposes, but also for your case, right?
Yes.
Is it fair to say that you cannot with certainty say that this case or this letter was not received or, an insight after trial, for instance?
It could have been. I mean, I can't tell from just looking at it.
In fair point. So there's no way to know when this would have even been sent to you, if it was sent to you at all, right?
That's correct.
Now moving to the next page of the same exhibit, what is page 3, I believe. Focused on the screen, the first word on that screen, if I'm reading it correctly, is Lynn, correct?
Yes.
Now, I don't mean to, play games here, Mr. Firehelm, but is your name Lynn in any case?
No.
Is this any indication that this letter was even sent to you?
Doesn't look like it was.
So it's fair to say that it was actually not even a letter to you at all about the case, right?
That's quite possible.
And going to the next page, page 4, and I don't mean to beat a dead horse with this or anything, but this one's also addressed to Lynn, right?
It is.
So much of this document, if we'd like to proceed to the next page, for instance, or some of the others, would suggest that, again, I believe Lynn is the name shown in the top corner with a date, actually, on this copy, right?
Yes.
And that date is August 29th of 2019, right?
Yes.
So this letter, too, was not addressed to you, right?
It appears not, yes.
So looking back on it, these ideas and insights from Mr. Mullis were not likely provided to you. Is that a fair assessment?
I don't remember seeing these, no.
So much of these ideas are either unbound in time or you're not the addressed recipient or intended recipient of this. Is that fair?
It's fair.
But drawing your attention to the other evidence in this case, and I don't, this specifically anymore. You discussed the DVR cameras or the security cameras on the Mullis farm too, didn't you?
Yes.
And that was on direct examination. You discussed how potentially those cameras would have gone out, right?
The foundation, direct examination of who?
Your direct examination.
Of Mr. Mullis?
Mr. Fire.
Oh, sorry. I withdraw that, yes. Okay.
And just for clarity of the record, during the direct examination of you, Mr. Firehelm, shortly before, you discussed those DVR security camera recordings, right?
Yes.
But that direct examination wasn't the first time you actually discussed those cameras, right?
Correct.
At trial, do you recall that you alleged, like Mr. Mullis had told you previously, that potentially the cat had knocked it off or interrupted the signal? Is that fair?
Todd told me that, and so did his brother Mike, and maybe even Lynn, too. I don't know.
So you investigated that evidence, didn't you?
Yes.
And you took not only Mr. Mullis at his word, but the support system that he had in place of his family too, right?
Yes, and then I went and looked at it, and maybe I shouldn't volunteer. I'm sorry.
Well, I'll go ahead and ask the next question. What is your insight on this issue specifically? What were you just going to say?
I grew up on a farm with dairy cattle and cats and corn rakes and so forth. I was proud of myself as an attorney when I walked into the courtroom and talked to jurors and argued cases to have that practical experience. And when I walked into the shed and looked at the window and how it was situated, cats like to lay in the sun. I think that window faced west in the cold, in the winter part of the year. All these things make sense. So that's what I meant. I'm sorry.
And again, you believed in your client's innocence through the trial, didn't you?
Very much so. And
you argued till the end of your representation that Mr. Mullis was not the one who had murdered Amy Mullis, right?
I did. That's correct.
But you knew what evidence would be essential to your case, didn't you?
I did.
And that critical piece of evidence was going to be Tristan Mullis' ability to provide an alibi for Todd Mullis at the time, correct?
Yes.
So when he changed his story specifically, or when he was potentially not going to be available to testify, you brought that to the judge's attention, didn't you?
I did.
Drawing your attention to what's previously been marked and admitted as State's Exhibit I. Let me know when you have it in front of you, Mr. Firehelm.
I have it right here on my desk.
For clarity of the record, Judge Bitter was the judge who presided over the case at the criminal trial level, is that right?
That's correct.
And so this email is dated August 13th of 2019, correct?
Yes.
And so this lengthy email with representatives of the state as well as for Tristan Mullis and your team too were included on this message, correct?
Yes.
And in this message specifically, you inquired about whether or not waiting for Tristan's potential issues addressed with his counselor to be addressed sufficiently so that he could testify at trial, right?
Yes.
And in order to ensure that he testify at trial, you floated the idea of a continuance to Mr. Mullis, didn't you?
I did. Sorry.
And in speaking with him about this, Mr. Mullis was adamant that trial should proceed as scheduled, wasn't he?
Very much so.
And so he was opposed to continuing the trial date, and that was your position too, wasn't it?
He was opposed to it,
And at this time, trial was set for September, right?
Yes.
So in the interim between this email and when you began trial, you deposed Tristan Mullis, didn't you?
Yes.
And that was when his story changed, yes?
Yes.
But you proceeded to trial in September because Mr. Mullis did not wish to ask for a continuance, right?
That is correct.
So when we look at that September timeline, you were also asked potentially about whether or not he would have a fair jury that, at least my understanding would be, would include potential farmers as well, correct?
That's how I understood it, yes.
But it was Mr. Mullis who wished for the case to proceed that month, right?
Yes.
In that month, I mean harvest season, true?
Yes.
And you were following the directions of your client, is that fair?
Yes.
So you proceeded to trial, but you had previously moved for a change of venue, right?
Yes.
Now, with about 40 years or more now of legal experience, is it fair to say that you know a judge would decide what venue to send it to rather than the parties specifically shopping for one?
Objection to the characterization of shopping in the state's question. It's inflammatory and prejudicial.
Would you like to revise your question, Mr. Duden?
Sure. Mr. Firehelm, in your experience as a lawyer with more than 40 years of practice under your belt, do attorneys get to choose what forum they go to when they move for a change of venue?
They don't have the final say, no.
Is it fair to say that a judge would make that ultimate decision?
Correct.
And in this case, a judge decided to move the venue to Dubuque County, right?
Yes.
And at that time, the concerns were ultimately revolved around whether or not Delaware County and Dubuque County were in the same media market, true?
That was one of the concerns, yes.
But you had asked prospective jurors when selecting a jury about potential exposure to media and their biases, didn't you?
I did.
So you sought to address those concerns to ensure your client would get a fair jury or a fair shake, right?
Yes.
And ultimately, when the jury was selected, did you have concerns about there being a fair cross-section or whether or not more representation of farmers or anything like that were going to be dispositive in this case?
No, I thought that this panel during voir dire was one of the more cooperative ones that I had encountered in trials, and I felt the cross-section was pretty good, actually.
So, in your opinion, the selection of the jury was fairly good for the case that was at hand?
I did, yes.
And to your knowledge, at any point in time, was it conveyed to you that there was a concern about a lack of a fair jury or cross-section being selected?
I don't recall. Once we got going and the jury was picked, no, I don't recall any concerns by Bob or me or Todd.
So is it fair to say that it wasn't really a concern for you and the Mullis defense team?
I think that would be fair.
You had spoken at length about Jerry Frazier while on direct examination in this case, correct?
I think so, yeah.
And specifically, at trial, were you pointing to Mr. Frazier as a potential person who would have motive to kill Amy Mullis as an option?
Yes.
You weren't necessarily saying that he was the murderer, were you?
No.
You were in fact pointing to many other people who could potentially have reason to commit the act, right?
Yes.
And again, at all times, you were maintaining the narrative that Mr. Mullis did not commit the act in question, yes?
Correct.
That he didn't murder his wife?
That's right.
Now, my understanding, Mr. Fireholm, based upon your prior deposition testimony, is it fair to say you view the role of a defense attorney as one to sow doubt or reasonable doubt into a case rather than to prove the alternate versions of a crime, right?
Exactly.
That the burden is the state's to prove that a crime was committed, in this case a murder, not your burden to disprove it.
That's correct.
And so, in this case specifically, you were looking to provide potential other avenues that would sow that doubt in this case or help you secure a not guilty verdict for Mr. Mullis, right?
That is correct.
Mr. Fireholm, in your experience, would you say that you provided zealous advocacy for Mr. Mullis in this case?
Objection to the vagueness of zealous advocacy, and it's inappropriate to ask Mr. Fireholm to judge his own performance.
Overruled.
Once again, I pride myself that, especially with the jury trials, that these situations for my clients are extremely stressful, important to them, and in Todd's case, the most stressful, facing a life sentence. And I don't take that lightly, and I believe I did everything within the time frame that we had, that I did everything I could to obtain that verdict of acquittal.
I guess is one of the last things that we need to talk about. Did you advise Mr. Mullis on his rights as it related to his ability to testify or not?
Yes.
Before trial, before he took the stand, did you work to talk through his testimony and help prepare?
Yes.
And in your professional opinion, or do you recall any instance specifically to which Mr. Mullis would have expressed concern or doubts about any of the process for him to take the stand?
I don't recall specifically. I mean, clients frequently say, you know, I don't want to blow it, I'm nervous, you know, those kinds of things. But I don't think Todd, you know, it wasn't like we had to drag him to the stand. And frankly, I thought he did a wonderful job.
So just to confirm, you didn't encourage Todd Mullis to plead guilty?
Correct.
You didn't advise him that he should waive a jury trial?
No.
You didn't tell him not to testify on his own behalf, or that he should, one way or the other, really, did you?
No.
You didn't force him to take the stand, right?
No.
And you never encouraged him to forego an appeal, did you?
No.
To that end, was the choice to plead not guilty and maintain his innocence all the way through trial, did you help Mr. Mullis maintain that objective through trial?
As best I could, yes.
In the arguments that were chosen to pursue, the argument specifically was to pursue believing that this was a murder, right?
Yes.
And as a brief recap, you reviewed the discovery yourself with Mr. Sabers and Mr. Mullis, didn't you?
A number of times.
You deposed witnesses in this case to ensure you understood the different theories of the state's case as well as possible theories for your case, right?
Correct.
You always believed that your client was innocent and held out to the jury that Mr. Mullis did not commit the murder did not murder Amy Mullis, right?
I did.
And you worked to address the pitfalls and concerns of Google searches or electronic evidence, didn't you?
I did.
And you sought to make sure he was prepared and ready to proceed in maintaining his innocence and helping prove his innocence when he took the stand, right?
Yes.
I don't have anything further, thank you.
Any redirect?
I do, Your Honor. Would it be possible to take a very short break just to get organized, and then I'll be ready to go?
Probably just a real short break. I imagine we're running short on time, so.
Thank you, Your Honor.
Okay, we'll take just a few minutes. Counsel, let me know as soon as you're ready. Mr. Firehelm, again, I'll go ahead and just leave the Zoom running.
Okay.
All right, they're going to take a break. And Dwayne, thank you for the gifts. And you got somebody that was actually in the chat. Julie Schwartz, woohoo! Yeah, Julie got one. Good job. All right, so let's go through. Cross came up, right? Okay, let me just put in here. So did you consider hiring experts? He said yes, if it were necessary. So this is all countering what the defense is saying. During the course of your investigation, didn't believe those experts were needed. He looked at all the law enforcement reports. He looked at the medical examiner's report. He looked at witness statements, audio, video, conducted depositions. He knew about Amy's affair with Raleigh and potentially others. What? Potentially others? That's kind of news to me. How many affairs did Amy actually have? We won't know because they didn't tell us. He went to visit Todd in person. Okay. Safe to say you were looking at other potential suspects? Yes. That mark on Amy's chin looks like she came down on that auger. So not just that she was resting there, but that she actually fell down on it. He thinks the mark on Amy's chin was from a fall. I'm like, okay, so now you're a doctor? I mean, I don't have any qualms against Mr. Firehelm, but how can you say with any reasonable certainty, degree of medical certainty that that's what that came from? But sure, whatever. Spent a considerable amount of time trying to lower Todd's bond. Yeah, it was like ridiculous, like $5 million or something really high. Todd was extremely stressed about being in jail. Of course, I think anybody would be. Then they talk about the trial testimony. Prosecutor asked Todd, somebody stabbed Amy twice in the back. It wasn't an accident. Todd agreed to that. Then they get to Tristan's testimony about he went to get a drink. He was only out of sight for 30 seconds. Everything kind of hinged on Tristan's testimony. I wonder how Tristan feels right now because his dad is in jail because of his testimony, basically. And he's there supporting dad. So I don't know. I feel sorry for him. Basically, Todd couldn't have committed this because he was only out of sight for a very short period of time. Tristan changed his testimony during trial. Was that shocking when this occurred? He said, yes, I bet it was. The 911 call. I got it queued up. I have the 911 call queued up, so we'll listen to that again. And you tell me if you can hear what they say is being heard. I don't think so, but he believed there was heavy breathing and Todd was trying to revive his wife. Ultimately, it came down to the weight of credibility for the jury, the 911 call. In your opinion, you provided the most fair trial Todd could have had. He says yes. Prosecutor, oh yeah, then there's this. The prosecutor told him someone was watching on court TV and called in about the muttering under the breath. When Todd's like saying, cheating whore, go to hell, blah. Somebody on court TV was watching and they called that in. That's what the prosecution based that all on. Wow. Dwayne gifting 5 more Trial TV Live memberships. Thank you, Dwayne. Appreciate it, my friend. Yes, little miss. Tristan changed his testimony. In his deposition, he said it was like 30 seconds to a minute, and then in the trial, he's like, no, Dad was away for like 5 or 10 minutes. Something to that effect. So, yeah, I wonder how Tristan feels right now. It was the judge that decided, oh, we might be having some issues, guys, with Comcast. Not quite sure. It was the judge that decided to move the trial. He didn't have to drag Todd to the stand, and he thought he did a wonderful job. So, he didn't have to. Not sure if. Yeah, Tristan, his testimony changed. Let me see if I can find it before they come back. Okay, Mom was cleaning the light fixtures. He loses sight of Dad, but doesn't know for how long. Deposition stated Dad was out of sight approximately 1 minute and 45 seconds. And he says, no, that's not accurate. So now he doesn't know how long he was out of sight. So initially he said 1 minute and 45 seconds. Now he's saying that's not accurate. So that's what I have. That's what I have in my notes. Trial Junkies United. What was the objection? What was the thing he mentioned about not appealing? What was the thing he mentioned about not appealing? I don't understand that. What was the thing he mentioned about not appealing? I don't know. I need more. I need more than that. Objection. I need more substance. I need more context. Was that Todd? I'm sorry. My head's like not there. Give me a little bit more context. Yeah. Well, it is what it is. Yes. This is like the little man in the corner. We have 44 likes, 55 people watching right now. Not too bad. Julie Schwartz, brand new member. Thanks to Dwayne. I'm usually so able to listen to a trial and form an opinion based on witness testimony, but this is a weird situation. I agree. Okay, thank you. Okay, Trial Junkies. Objection. Comeover asked him, did you tell Todd not to appeal? He said no. That made me think he didn't appeal. Oh, was that... I totally missed that. Okay, let me think about this for a second. Did you ask Todd not to appeal? No, he did not ask Todd not to appeal. He did not ask Todd. That made me think he didn't appeal. Hold on a sec. I think he did appeal. Hold on. That came across... no, he... Oh, shit, get back. Oh, man. I hate when they come back like that. All right, hold on. Remind me of that question in the next break, Trial Junkies.
Please be seated. Ms. Nichols-Cook, are you ready to pick back up?
Yes, thank you, Your Honor.
All right, you may proceed when you're ready.
Mr. Fireholm, you were asked on cross about an email that indicated Todd was stressed and having trouble reviewing discovery. Do you recall that?
I do.
To your knowledge, had Mr. Mullis ever been incarcerated before? And to your knowledge, was this the first time that Mr. Mullis was learning about Amy's affair with Jerry Frazier in the discovery?
I'm not certain that's true.
Did you do any investigation to figure out if that was true?
We talked about it, but what I'm being careful here is I'm not certain that Todd told us that he knew about it before this discovery material was reviewed or not.
Would you agree, though, it'd be upsetting?
Certainly.
Yeah.
Certainly.
I want to reference States Exhibit F, the email from April. I think you have that.
I do.
And in that email, it says we need to have an expert take a look at the autopsy. Is that what it means?
That's what it says, yes.
But you never did do that.
No.
Okay. Do you recall a note that was passed to you?
I eventually saw it. I'm not sure when.
Did you understand that to mean that your client didn't know what you were going to say in opening?
I'm not sure what was intended.
Did you talk to your client about it?
No, I don't think so.
And you would agree with me that Mr. Mullis never told you he believed it was a murder?
I'm not going to say he said those words, no.
You talked on cross about it was the state's burden to prove beyond a reasonable doubt that a crime had occurred. Do you remember that?
Yes.
And would you agree that in your opening you conceded a crime occurred?
Yes.
And would you agree that Todd always maintained it was an accident?
He always maintained that that was possible, yes.
And in your deposition you testified that Todd never agreed with you that it was murder. Do you remember that?
I think that's what I said, yes.
You testified on cross that Tristan, you considered him to be an essential witness because he was an alibi. Do you remember that?
Yes.
Tristan's testimony was only essential if you believed Amy's death was the result of a homicide, right?
Yes.
You were asked about the change in Tristan's testimony in his deposition. Do you remember that?
Yes.
Did you do anything to present all of the prior statements Tristan had made before his dad was arrested that indicated he was with his dad the whole morning?
I think we did, yes.
You were asked about the Google searches and the electronic evidence. Do you recall that?
Yes.
And you've also told us that you prefer paper over electronic documents, right?
As far as maintaining the files and exhibits and discovery, yes.
And I've showed you several things today that come from electronic discovery that you didn't have before.
Yes.
I want to go briefly back to Exhibit 233 that the state showed you and asked you about as well. Do you recall testifying in your deposition that this was Todd's handwriting and a letter you received from him?
No, I don't recall those specifics, no.
Let me find the page for you here. Elena, you put it in the end. Okay, Mr. Firehelm, you have a copy of your deposition in front of you, right?
I do.
And for the record, it's our Exhibit 323. If you could look at page 19 and start at line 22. And read through page 20, lines 8 through 13.
Read to how far?
Page 20, lines 8 through 13.
Okay, I've done it.
And does that discuss letters from Todd?
Yes.
If you would go back to looking at 233, and we'll scroll to the third page. Do you see a date there at the top? I'm sorry, it's not the third page, it is the fifth page. My apologies.
Yes, I see that date, August 29th.
2019.
Yes, correct.
This would have been about a month before Mr. Mullis' trial?
About 3 weeks, yeah.
And you testified earlier that you spoke with Todd's sister Lynn a lot during your representation of Todd?
Yeah, quite a bit, yes.
And that Lynn would give you information as well?
Yeah.
And that she would call you or email you and say Todd needed to see you or talk to you?
That was common, yes.
If you go down to page 10 of 233, do you see the handwriting in the middle of the page at an angle?
Yes.
What does it say?
Lawyers first, then Lynn or Mike.
So is it entirely possible that this letter was sent to you?
Objection, speculation.
Overruled. The witness can answer if he's able.
Anything's possible, but I just don't think so.
But you were representing Mr. Mullis August 19th, 2019. So you would have been one of those lawyers referenced on page 10?
I assume so, yeah.
Do you remember signing an affidavit regarding your representation in this case?
Yeah, I remember signing one, yes.
It's Exhibit 224. We can show it to you. I don't know if you have it.
I think I have it.
Can you see the one on the screen?
Yeah, I just found it. I have it in front of me.
Okay. You were asked about the 911 call that was played for Todd on his cross-examination.
Yes.
And in this affidavit, can you read paragraph number 10?
Objection.
I did not.
That's not in evidence, Your Honor. This is not an admitted exhibit, and consistent with the court's order on day one, affidavits have not and likely would not be admitted.
Your Honor, I was asking the witness to read it to himself. I apologize. That wasn't clear.
Okay, so for now, at least, the objection will be overruled.
Let me know when you've had a chance to read paragraph 10.
I have.
And do you recall me asking you earlier about whether you asked for move for a mistrial after that 911 call and the arguments were made by the prosecutor?
Yeah, I think you did.
And with all of the decades of experience, have you moved for a mistrial before?
Yes.
And do you agree that you could have and should have in this case?
In hindsight, I could have.
And in fact, you've said before you should have.
Right.
You were asked about conducting depositions leading up to this trial. Do you remember that on cross?
Yes.
You testified earlier that you didn't conduct any research or investigation before those depositions. Is that still true?
Research as to what?
Well, to prepare for depositions regarding the electronic evidence or any other topic?
I reviewed the discovery that had been produced.
Other than reading police reports, you didn't do anything else. Is that correct?
Talk to Todd, talk to Bob, Lynn, Mike, those kinds of things.
And you didn't consult any experts to help you understand the evidence?
Objection.
That is correct.
Answered within the scope of the direct and the cross, Your Honor.
Overruled. If there is an answer, it will remain in the record. Okay. You don't think there was? Mr. Firehelm, do you remember the question?
I started to say it. My answer was that's correct.
You were asked on cross about complying with Todd Mullis's wish to not continue his trial. Do you remember that?
Yes.
Do you disagree that you didn't comply with anything else that Todd asked you to do as far as consulting an expert regarding whether her injuries were the result of an accident?
Objection argumentative in the state's testimony.
Overruled.
I don't do. My response to Todd's references to getting experts as ignoring him, or whether I complied with him. I think I've explained that before, how I viewed that.
You were asked several questions on cross about investigating issues. Are there actions you took that we have not discussed today?
The only thing I can think of is in some cases, as a member of the Iowa Association for Justice and the criminal group of that organization, we have a pretty active listserv. So once in a while, an issue will come up, and rarely will the attorneys, and I'm one of them, will we give the name of a case or a client's name or something. But if it's an evidentiary issue or something like that, I think I probably did that in this case. I don't remember specifics, but that's one thing other than what we've talked about, I guess.
Thank you. I wanted to follow up on the testimony by Deputy Himsath at trial about the timing of those Google searches. Do you recall that?
Yeah, kind of.
Do you know why you didn't impeach him? That he had the calculations of the timing of those messages wrong?
I guess I thought we did to some extent. I don't remember exactly how the record reads.
Do you understand how to do a UTC calculation?
Yeah.
So if you didn't impeach him, you don't have a reason for that?
I guess whatever I did, I did. I'll just stand on the record.
You were asked on cross about the hunter safety certificates and guide and the questions you asked Todd Mullis. Do you remember that?
Yes.
Did you obtain a copy of that guide and compare it to the Google searches?
I don't believe so.
Did you talk with Todd's daughter or Tristan about what types of searches they might have done?
I don't think so.
Did you only put Todd on to explain that, to testify?
Yes.
You were asked about your email in April where you believed it was murder based on your review.
Yes.
And you were asked about working with an accident reconstructionist or a biomechanical engineer, I think?
Yes.
Have you worked with an accident reconstructionist before?
Yes.
But you did not do that in this case?
Yes. That's correct.
Do you recall being asked in your deposition whether you had the consent of Todd Mullis to concede it was a homicide prior to making your opening statement?
I don't recall specifically, no.
If we could go to your deposition, page 22, I think, or is that 23? line 23, page 22, line 23.
Yeah, I see that.
And your answer to that question about whether Todd consented was no. Not like I'm okay with that, no.
That's what it says.
So any testimony you gave today that you think Todd knew is different than your testimony from your deposition?
Well, if that's the way you interpret it, that's not what I meant. What I testified to today, I think, is that I felt that Todd had acquiesced in that concept.
So, Mr. Firehelm, did you understand Todd to always maintain that it was an accident that injured Amy?
I'd have to answer that yes. Yes, but, I guess.
But you did not present that theory or investigate that theory for him. Is that accurate?
Didn't present it. I'm not saying we did investigate it.
But did you talk to any experts about it?
Objection,
No.
Your Honor. This is asked and answered and cumulative to the record at this point.
Objection is overruled. The answer will remain in the record.
Your Honor. Oh, wait.
Any redirect?
I'm sorry, Your Honor, I have one more question. May I go back?
You may.
Mr. Firehelm, in your opening statement, you told the jury that Todd's prior statements to law enforcement were wrong. Do you remember that?
If that's what I said, yes.
And then you put your client on to testify in your defense without any corroboration.
Objection, Your Honor. From just clarification of the record purposes, I believe that's necessary to say your defense, I believe, should be clarified if possible to Mr. Mullis's defense.
Right. Certainly that's the way the court understood it.
Thank you, Your Honor.
Do you want me to repeat or rephrase the question?
Please.
If the transcripts show in your opening statement that you told the jury Todd was wrong when he talked to law enforcement, and then you put Todd on in the defense in chief and expected the jury to believe him, that was what you did?
What I told the jury is that Todd told law enforcement that she fell, that it was an accident. That's what he initially thought. He testified on cross-examination that it was a murder. So I'm not sure what you mean, I guess.
I'll move on and follow up on that, and I know I have to be done. Todd's testimony at trial is reflected in the transcripts, right?
Yes.
And so if the prosecutor asked him, based on what you've heard at this trial, do you now know it's murder? Would that be different than Todd's belief that it was murder versus an accident?
I can't say.
Okay, and Mr. Mullis wasn't qualified to review the autopsy report or do an accident reconstruction to have his own belief.
I'm sorry, what was your objection? I didn't hear it.
Well, one, this is irrelevant, and it's not facts in contest, so it's immaterial and far more prejudicial than probative, because certainly no one is contesting that.
Well, I think we're getting a little far afield here. Sustained.
No further questions?
Any redirect?
Briefly, Your Honor, permission to share the screen?
You may.
Perfect. Drawing your attention to what has been marked previously as Exhibit 350, and specifically drawing your attention to page 75, line 25. Do you see that, Mr. Firehelm?
350?
Yes.
So it says, I want to talk to you about some of the times that you're given. What's UTC mean on this printout? That was your question to Deputy Himmelsath, wasn't it?
Yes.
To which he responded Central Standard Time, right?
Yes.
And you just say, if the internet tells you you're wrong, would you disagree? And he said, can you ask that again? I guess I've never had the internet tell me I'm wrong, which I believe is a joke, or also just maybe in jest. In either way, have you ever researched that UTC is the successor to Greenwich Meridian Time, GMT? To which he responded, okay, I've never searched that, no, right?
Yes.
Now continuing down through page 77, line 5, let me know when you've reviewed it or if you need it slowed down. Have you reviewed it, Mr. Firehelm?
I see it.
And in this case, so you did actually impeach Deputy Himmelsath on UTC time specifically, right?
I thought I had.
And so the record would speak on that point. Would you agree?
Yes.
Did you author your affidavit that was referenced earlier?
Yes.
In the time, it was not authored with the benefit of having your file, right?
That's correct.
Nor when your deposition occurred did you have the benefit of your file. True?
That's correct.
Because you had given it to ensure that the successor attorneys representing Mr. Mullis could continue their representation in the underlying criminal case and on appeal, right?
That is correct.
Knowing now, with the benefit of the records and the transcripts before you, is your testimony today true and accurate to the best of your knowledge?
Yes.
I don't have anything further, Your Honor.
Anything further, Ms. Nichols-Cook?
Just, Mr. Firehelm, do you know if you've ever seen the cell phone extraction data from Tristan Mullis' phone?
I don't think so, no.
And then just for purposes of the record, do we need to identify if there's someone in the room with Mr. Firehelm or not?
We can. Mr. Firehelm, is there anyone in the room with you? I guess I'm not sure if you're in your office or elsewhere.
I got the door locked and I've been here by myself all afternoon.
Thank you. I guess back to you, Mr. Duden. There was another question from your
None needed,
side.
Your Honor.
You're done?
Yes.
Okay. All right, Mr. Firehelm, it sounds like that should conclude your testimony. Thank you. I'll go ahead and end the Zoom at this time.
Thank you.
too many screens to shut down there. Okay, it is just about exactly 4:30, so it looks like this will be our ending point for the day. We'll plan on picking back up at 9 a.m. on Monday. Council, if you'd like to stop back in chambers, obviously we can touch base about the schedule. Anything else we need to do on the record before we break for the weekend? Anything on behalf of the applicant? No? Anything on behalf of the state?
No, Your Honor.
All right, thank you. Have a nice weekend. I'll see you on Monday.
All right, hang with us because I'm going to play the 911 call. I'm going to play the 911 call because that has been irritating me since the day I watched this the very first time. So just hang with us for a second. And listen to it honestly. Don't listen to it. Oh, are you kidding me? All right, hold on. I got to go in. Oh, it happens at the beginning. Okay. All right, listen to it honestly. And this is from our feed. So. All right. So listen to it honestly. Tell me what you guys think.
Go ahead.
Delaware County 911, what's the address of your emergency room? Oh, this is Todd. Hello? Where are you at? I'm on the road. I'm out of breath. Okay. What's going on? My wife, what the hell? She saw the full pork sitting in the barn. Okay. She's not responsive. I'm just me and my son bringing it. Okay, so your wife is in a barn. You said she's unresponsive? No, she's in a bull-ducking, what do you call corn fork. I don't know if she tripped. I don't know. She was halfway out the door. I sent my son over to check on her. Okay. She's yelling at me and I'm on the ride. Okay. She's just gone. Okay. We'll get an ambulance for in just a second. I'm headed there. I'm about to Oneida. Okay, so you're headed to where? Okay, what's the hospital? I just grabbed her and threw her in the truck. So my son pulled me. Okay, you're headed to the hospital and she's in your vehicle? Yes, my white truck. Okay, just a second here. Is she? There's no pulse. There's no pulse. Can you just get on the phone for me? Just a second. I'm going to have another dispatcher get on. I'm going to ask you to pause it. Can you pull over? I can. Okay, how about you pull over? Sir, what's your current location and we'll get an ambulance headed your way? Oneida. Another dispatcher, get on. I'm going to ask you to pause it. Can you pull over? I can. Okay, how about you pull over? Sir, what's your current location and we'll get an ambulance headed your way? Oneida. Brian Coleman's new house. I can be right in Oneida, right? East of Oneida. Oneida. Okay, I'm ready for her. Did you guys do anything? She says, there's nothing. Okay, what is your name, sir? Todd Mullis. And what are you driving? White Chevy. A white Chevy. I can be closer. A white Chevy truck? No, I don't feel anything. God damn, she's there. Cover her up a little bit. She has that fucking pants off. I gotta get her out of this shit. Do you feel anything? 25 Manchester. Do you see anything? Do you feel anything? 28.5 Manchester. We got a kid. Somebody stuck his wife in the vehicle.
vehicle unresponsive. They're coming through Oneida. I asked him to stop there. We've got the ambulance paged out. Can you head that way?
Can I get a little closer?
He said Oneida.
Can I go a little closer?
I've got an officer almost to where you're at.
Okay.
Okay?
I'll turn it off so they can get there.
Go ahead.
They can pull right in here. Cut. I'm just east of Oneida.
Okay, all right.
Do you feel anything? Amy. Amy.
Okay, so what happened that she's not conscious or breathing? What?
She fell on a fork. I had took out a fork on her. It was an old fork sticking in somewhere, and then she was halfway out of the barn. Like she was calling to get out, and then Tristan yelled, and I ran over there, and she's laying there.
And pulled it out of her.
I couldn't get her out of the barn. The doors were narrow, and she's not responsive.
With the force of the tractor at this moment, but she's unresponsive. We haven't pulled over alongside the road. Was this like a pitchfork?
One of them old corn forks.
Right. That's like a silent fork?
Yeah, well, it's kind of got a curve on it. I don't know how that freaking happened. I'm sorry about my cursing.
Okay. So is she bleeding?
I can't tell. When I seen it, she was face down.
Who pulled the pitchfork out of her? How old
I couldn't get out of the door.
How old is she?
What is she, 38?
Okay.
She's 38 or 39.
Okay.
She is not responding.
Okay.
Come on.
Sir, do you feel comfortable doing CPR?
I can try. I'll try anything.
Okay.
I'll try anything. I guess she's laying on my son's lap.
Is she flat on the? Are you able to get her flat across maybe the seat?
Well, I think it's from the back of the truck. But she's laying on my son's lap.
Okay.
Oh my God. When I push on her, she got like foam in her mouth.
She's foaming from the mouth. I don't know how to get her laid flat.
She's...
You know what I mean? She's laying across her son's lap.
Oh, she's got a little blood, around her back.
Is he able to get on, maybe he can get on the floor of the truck and you can lay her across the seat so we can get her flat?
Go, Tristan, get out, and we'll lay her on the, and we'll get her on the seat. Okay. Oh, shit. Get out. Get out. We'll leave the seat back a little bit.
Where's the seat?
Okay, she's very flat. I'm trying to hold on to the phone.
Right. Can you put the phone on?
What do I do?
Okay.
Lay her flat as I can.
As flat as you can. Move your hands on her breastbone in the center of her chest, right between her nipples.
Okay.
Place your other hand on top of that hand.
Okay.
Okay. Pump the chest hard and fast, at least twice per second, 2 inches deep. Let the chest come all the way up between pumps, and we're going to do this until they get there and can assist. Okay.
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 Twice per second. Yep. 1, 2. 1, 2. New house building just
doing the compressions until they can help and take over, okay? Keep going, you're doing fine. Keep going.
Come on, respond. Please, Cole. Come on. Come on. Come on. Good. Come on. Oh, shit. One of them goes.
Is the officer there with you, sir?
Yeah, he's here.
Okay,
It's, what is his name, Luke?
that's fine. Do you want me to stay on the line with you, or are you okay?
No, I can't talk on the phone.
Okay, all right.
My son's right here. I gotta.
Okay, all right.
Okay, is the state ready with a witness?
Yes, sir.
Go ahead.
So all I heard was, come on, respond. All he's like, come on, respond. Come on, respond. I didn't hear, go to hell, you cheating whore. I didn't hear any of that. And then this is where the state comes up and she's, did you hear? And then, yeah, I honestly didn't hear anything. I heard, come on, respond. That's all I heard. Come on, respond. Come on, respond. So just taken like that, that's what I heard. But then, you know, she says, you know, I'm not sure where she brings that up. I think it may have been after all of this. I'm not sure where the prosecutor brought it up. Because remember, somebody from Court TV is watching this, and then they called in and they say, hey, I heard that. So it might be another day that they did that. So nice. So, all right. So that concludes Todd Mullis, day 5. We are going to go over to Monica Cementili at 6 o'clock. Aaron's got a redirect set up. But before I let you guys go, definitely look up in the sky tonight. Tonight, February 28th. As the sun is going down, maybe 7:30, 8 o'clock, find the moon, and then you'll see Venus and Uranus are like going to be right there. And then you'll see Venus is pretty bright. Jupiter is pretty bright. So you should be able to see them. So definitely check those out tonight. I'd say, you know, whenever you go out, try to find the moon. It's like a crescent tonight. So, all right. Yes, hold on. You'd think the attorney would have recalled them. Yep. Sorry, hold on. Therapist, you know. Yep. Someone from Court TV heard him say that. They called it in, told the prosecutors. Yep. And then the prosecutor told Firehelm. That's what just came out in today's testimony. Somebody was watching Court TV. They said they heard that. They called the prosecutor. The prosecutor told Mr. Fairhelm. And, yep, that came out today. So, all right, guys, I'm going to take a quick break, and I'll see you guys at 6 o'clock, which is about 20 minutes at Monica Cementili. Redirect is set up, right? Redirect is set up. We're checking right now for a redirect. But, yep, have a wonderful weekend, everybody. Thank you for joining us. Thank you to Aaron. When the sky's like, when the moon hits your eye, like a big pizza pie.
We're going to day 17.
Day 17, afternoon.
Okay.
All right, so thank you to Aaron. Thank you to our mods. Therapist You Know and OnlyFan, thank you. Hellcat, Widespread Panic. Fala, thank you guys. Appreciate you all. Brat, thank you for being with us today. And we will see you guys in 20 minutes. And then we'll also be streaming Monica over the weekend too. So If you can't join us today, maybe check us out over the weekend. So have a great night. Please join us over at Monica Cementili. We're going to pick up on day 17 afternoon. All right, see you in a bit. Bye.
Yeah.